का पैसा बाहर से बुलाना हो तो निकाल कर दे दूंगा। इसका 1% लेने के लालच में मैंने काम शुरू कर दिया। मेरे साथ पड़ोस के रहने वाले करीम आए, बोला मेरा पैसा ट्रांसफर करा दीजिए। तो मैंने मुझे नगद 10,100 रुपये दिए। मैंने मोहम्मद के अदान को बुलाया, बताया कि पैसे ट्रांसफर करना। अदान मेरे पास आया, करीम द्वारा बताया खाते में पैसा डाल करके लेके चले। करीम का कॉल आया कि 30,000 रुपये निकालने हैं। मैंने अदान का पते से भेजा, 30,000 रुपये निकाले थे। फिर दूसरे में 29,500 रुपये का आए इनके खाते में। इस तरह 51,000 रुपये आ रहे थे, निकाल करके दे देना। मैंने अदान को बताया 51,000 रुपये आ रहे हैं, ATM से निकाल करके करीम को दिए थे। करीम ने मेरे खाते में 55,000 63,000 डलवाए थे जो अदान करीम को दिए थे। मेरे पास इंडसइंड बैंक का खाता सोएंसो नंबर है जो मेरे भाई के नाम से है, जिसको मैं चलाता हूँ। मोबाइल नंबर सोएंसो। तो ये सारे पैसों की जो ट्रांजेक्शन है, ये
इसमें 420 क्या है ये बताइए।
नहीं बनता, हमारी उम्र भी 20 साल की है।
यस, जस्ट अ मिनट, 420 क्या है इसमें?
ट्रांजेक्शन में पार्टिसिपेट किया है पूरा, उसके बदले में कमिशन लिया है।
नहीं तो ठीक है,
एक कनेक्टिविटी है इन सभी लोगों की जो है, इस तरह से चीट करके पैसा बुलाते हैं।
चीटिंग क्या है वही तो मैं पूछ रहा हूँ, व्हाट इज चीटिंग?
धोखा दे करके कि आपको हम वर्क टू होम में जॉब दे रहे हैं, उसके बाद में उनसे पैसे मंगाना।
नहीं तो आपने तो वर्क टू होम में किसको चीट किया बता ही नहीं है इसमें कुछ। ये सिर्फ करीम का बता रहे हैं आप। उसने लाए पैसे दिए, इसने ट्रांसफर कर दिए,
बस करीम का रोल इतना ही है।
ये किसके पैसे थे, क्या किया है इन्होंने, चीटिंग में कैसे इन्वॉल्व है?
यस माय लॉर्ड, मैं क्लियर कर देता हूँ उसका। टेक्निकल डिपार्टमेंट क्लियरेंस के कार्यों करता है। कंपनी के द्वारा पैसों की मांग की गई, जो पैसे मना करें कंपनी का मोबाइल नंबर से व्हाट्सएप फोन के।
अरे वर्षा ने कंप्लेंट करी है ना, वर्षा के पैसे भी इन्होंने कैसे गायब किए हैं, इतना ही बताना है आपको।
सर इसमें वर्षा के पैसे इनके द्वारा डायरेक्ट कहीं उसमें नहीं गए। जो दूसरा पक्ष था,
हाँ,
अदनान, उसके पास में जो है ये ट्रांसफर के लिए मोहम्मद करीम, इसके द्वारा जो है ये पैसे के लिए ट्रांजैक्शन करवाया है और इसने ट्रांजैक्शन किया उसके बारे में। साकिब अंसारी ने।
वर्षा ने किसको पैसे दिए?
ये मोहम्मद करीम के अकाउंट में है।
वर्षा ने मोहम्मद करीम को पैसे दिए नौकरी लगाने के लिए?
यस, जॉब जो है घर बैठ के जॉब के नाम पर ये पहले आवेदन किए गए। आवेदन के आधार पर हाँ, इन्हीं को मोहम्मद करीम को आए हैं पैसे और मोहम्मद करीम ने पैसे इसके जरिए ट्रांसफर करवाए। बस इतना है।
इनसे क्या सीज किया आप?
5,500 रुपए सीज किए।
आप लोगों को तो बेल नहीं देंगे। 2-2, 3-3 लेवल पे आप लोग क्राइम करते हैं।
मेरा निवेदन,
इट इज वेरी डिफिकल्ट टू डिटेक्ट।
लॉर्डशिप, मेरा निवेदन सुने एक बार प्रोसिक्यूशन का पूरा केस।
और ये उत्तराखंड के रहने वाले हैं।
लॉर्डशिप,
एप्लीकेंट हैज फाइल्ड फर्स्ट बेल एप्लीकेशन अंडर सेक्शन 439
20 साल के हैं, 41A का नोटिस सर्व नहीं हुआ।
एप्लीकेंट इज सेड टू हैव कमिटेड चीटिंग बाय यूजिंग टेक्नोलॉजिकल मींस थ्रू मोबाइल फोन। इट इज वेरी डिफिकल्ट टू ट्रेस आउट cheating done by such accused persons through mobile phone and computers. Full stop. Applicant is not resident of Madhya Pradesh and he is resident of Uttarakhand. If he is released on bail, it is there is likelihood that applicant may abscond from law and will not appear in trial. In these circumstances, application is dismissed. Yes. ये फोन वोन वालों को तो बिल्कुल नहीं देंगे।
लॉर्डशिप, मेरा एक निवेदन सुने। ये कंपनी पुणे की थी।
ये सब 15-16 साल के लड़के यही कर रहे हैं। नेक्स्ट, आई डोंट वांट टू हियर यू। यस, नेक्स्ट।
लॉर्डशिप, लिबर्टी दे दो चालान।
नो लिबर्टी। यस।
Lord, in this case, earlier the criminal antecedent of the present applicant was called, my lord, by the state, my lord.
Yes.
As far as my knowledge, that there is no criminal antecedent. Applicant is aged about 48 years. आप
ये स्टेट क्या किया है?
क्रिमिनल रिकॉर्ड नहीं है मिलोट।
कितने टाइम से आप जेल में?
मिलोट ये हम हैं 29/11 से हैं मिलोट।
29/10/23 से जेल।
29/10/23 मिलोट।
यस, क्या किया है?
इनके द्वारा बके से मारने के संदर्भ में आया है मिलोट। विवाद के दौरान राघवेंद्र सिंह, नीलेंद्र सिंह हाथ में लाठी लिए, सत्येंद्र सिंह बेटू हाथ में बका लिए गाली देते हुए सत्येंद्र सिंह और राघवेंद्र सिंह ने लाठियों से मारने लगे। तब आयुष सिंह बीच बचाव करने के लिए आए। इसमें आयुष इंजोर्ड है माइलोस। सत्येंद्र सिंह और बेटू के हाथ में बकीर से आयुष ने मारा, बाएं हाथ और पैर में बका मारा, याज्ञवेंद्र और सुरेंद्र के बीच बचाव किया।
क्या
उनके
इंजरीज
साथ मान उसको भी। सुरेंद्र सिंह को जो है वन लेसरेटेड वुड जो है लेफ्ट पैराइटल रीजन पर है, लेफ्ट पैराइटल रीजन पे ये एक है, और जो दूसरा है आयुष, उसको 4 चोटें हैं जिसमें ऑल लेसरेटेड वुड है, मतलब फोरहेड पे है,
ये तो सारे लेसरेटेड हैं, आप बता रहे हैं
डीप
उन्होंने
है, लेसरेटेड वुड है, ज्वाइंट पे
बका से मारा बता रहे हैं।
कटिंग करेंगे इसको क्वेरी रिपोर्ट में क्लियर
सारे
किया।
लेसरेटेड वुंड है ना?
यस माइलर, और क्वेरी रिपोर्ट में दिया है सिर की हड्डी में फ्रैक्चर है।
फर्स्ट एप्लीकेशन यस।
दूसरी सिर के ऊपर की चोट गंभीर है, सिर की गंभीर चोट ठोस हथियार द्वारा लाई सब लेसरेटेड है, दोनों क्वेरी रिपोर्ट है।
हाँ, ये बका सीज किया है आपने?
मेमोरेंडम है इसका बका।
चार्जशीट इज फाइल्ड।
Let's see.
Yes,
Yes,
my
charge
charge
sheet has been filed, my lord.
Applicant has filed first application. Police
एक
station.
बका सीज हुआ है इसके पास।
Counsel for applicant submitted that he is innocent, falsely implicated. Allegation is made by prosecution that assault is done by Baka. All injuries which is found on victims is lacerated wound which could not have been caused by Baka. It is further submitted that applicant is in jail since 9/10/23. Investigation is complete and charge sheet has been filed. Applicant is a man aged about 48 years with no criminal records. He will regularly attend the trial and will appear before the court as and when required. Government advocate opposed and submitted that offence is heinous. Heard the counsel for the parties. Investigation is complete. Charge sheet has been filed. In these circumstances, application is allowed. Applicant be released on bail on condition that he will regularly attend the trial and will not seek unnecessary adjournments in court.
Lordship, on last date of occasion, state was directed to produce the status report.
कब से आप जेल में?
Your Lordship, from 19/12/2020, Your Lordship.
20 क्या किया आपने?
302, Your Lordship, 307 and 25 and 27 of Arms Act, Your Lordship.
ये स्टेट
मतलब 18 क्रिमिनल केस इनके अगेंस्ट में है मालूम, और इनके द्वारा जो है रेत से भरे हुए ट्रक के ड्राइवर को जो है वो पहले रास्ते में लकड़ी डाली, वो उसको उठाने के लिए जैसे ही बाहर निकला तो उसको बंदूक मार दी। इसमें जो 4 आई विटनेसेस है, 4 में से एक हॉस्टाइल हुआ है, बाकी अभी 3 के होने और बाकी है उसमें।
They are not turning up, Your Lordship. Even the warrants has been issued.
4 साल से जेल में है।
मतलब सभी पहले के भी जो केसेस हैं इनके सब
कितना रिकॉर्ड है इनका?
18 केसों का रिकॉर्ड है हमारे पास।
Lordship, in this I have been falsely implicated, Your Lordship. There is the only evidence that has been made against me that I.
There are eyewitnesses.
Lordship, the only eyewitness that is being examined is hostile, Your Lordship. And others are not turning.
4 eyewitnesses.
But they are not turning up. Even the warrants has been issued, Your Lordship.
18 केस हैं, who will come?
Any strict condition will be put.
Applicant has filed second application under section 439 police station offences. Counsel appearing for applicant submitted that he is innocent, falsely been implicated in the case. He is in jail since 19/12/90 for about 4 years, looking to long period of incarceration, and fact that witnesses are not coming forward to give evidence in the case. Applicant be released on bail. Government advocate opposed the application. It is submitted that applicant is having criminal record of 18 cases against him. He is a
3 केस तो 302 के हैं।
he is hardcore criminal. Other offences committed by applicant is also heinous in nature. In this case also, applicant has murdered 1 person. Looking to his record, he may not be released on bail. Heard the counsel for the parties. Eyewitness account is available against the applicant in the case diary. Full stop. Considering the evidence available against applicant, bail application is dismissed. Trial court is directed to expedite the trial.
I'll
and
withdraw.
preferably complete it within period of 6 months. If there is no progress in trial and no witnesses examined, then applicant will be at liberty to file repeat application for grant of bail. State is directed to keep the witnesses present before the court for examination, before the trial court for examination. नहीं आएंगे then I'll consider for bail. State आगामी दिनांक में आपके विटनेस नहीं आएंगे then I'll consider him for bail.
Well,
Your Lordship, so 3 months कर दें, almost 4 years.
18 cases हैं आपके.
number 30.
Lordship, this is my repeat bail application on behalf of the applicant, Lordship. Offence is 376 2N and POCSO Act, Lordship.
Yes.
This is not a good case, Lordship, but there is one thing I have found that this is very peculiar, Lordship. The 161 and the 164 statement of the prosecutrix. The allegation in this case is that the mother and the father were divorced and the daughter used to come to father and the father raped her. This is the allegation.
टू से
12/1/22.
12/1/22 यस लास्ट डेट में आपने स्टेटस
More
रिपोर्ट
than 2 years.
सर
More than 2 years.
यस मैम
Third will.
Seven witnesses. 8 witnesses has been examined.
आउट ऑफ 70
Out of 70.
यस मैम सर सी इज लेडी एंड 4 छोटे छोटे बच्चे हैं सर जो परेशान हो रहे हैं, बच्चे छोटे छोटे बच्चे हैं सर।
आप क्या हैं?
एक बच्चा 13 साल का, एक 10 साल का, एक 9
आप
साल
हैं
का,
कौन?
एक 7
Who
साल
are you?
का। सर केस इज 302 ये सर नंद थी। इस केस में 2 डायरेक्शन है। एक डायरेक्शन डॉक्टर के सामने होता है, वहाँ ये कहती है कि हमने खुद आग लगा ली, पति ने बचाया। उसके बाद सेकंड डायरेक्शन तहसीलदार के सामने होता है, उसमें ये कहता है कि लीला चौधरी ने हमको आग लगाई। अनेक्सर A4 मैंने फाइल किया है सर।
तो तहसीलदार को एग्जामिन हो जाने दीजिए।
सर
वो kerosene smell is there, तो second declaration reliable।
सर 4 चिल्ड्रन किड्स हैं सर, छोटे छोटे हैं सर, वो 2 साल से परेशान हो रहे हैं। कोई देखने वाला नहीं है सर, फैमिली में कोई नहीं है सर। 13 साल, 10 साल, 9 साल, 7 साल के 4 बच्चे हैं सर, उसको देखने कोई केयर करने वाला नहीं है सर।
हस्बैंड संभालेंगे?
हस्बैंड तो बाहर जाता है, रिक्शा चलाता है सर, तो बच्चे घर पे अकेले हैं, कोई बच्चों को देखने वाला नहीं।
डोंट टेक एनी सिंपैथी ऑफ चिल्ड्रन।
सर लेडी है, अब 2 साल।
आपने एक आदमी को जिंदा जला दिया,
अब 2 साल तो
अब आपको अपने बच्चे दिख रहे हैं।
सर आई एम प्रेसिंग फॉर डिले ऑफ ट्रायल।
समय नहीं दिखे।
सर आई एम प्रेसिंग फॉर डिले ऑफ ट्रायल।
टाइम नहीं आपको समझ में आया कि क्या कर रहे हैं?
सर
बैंक डिक्लेरेशन है आपके अगेंस्ट में?
नहीं सर, डॉक्टर के सामने उसने ये बोला था कि हमने खुद आग लगा ली। जो लव मैरिज करी थी, वो लव मैरिज करी थी सर।
kerosene smell is there, तो डॉक्टर
नहीं, अगर पहला वाला बिलीव करेंगे उसने
तो
खुद लगा लिया।
पहले वाला बोले खुद आग लगा ली, मतलब केरोसिन से नहीं है मालूम।
और
तो
क्या
खाना बनाते समय
आप अनेक्सर A4 देखना सर, फोरम में
बैंक
सब पढ़ के बताएं।
डिक्लेरेशन के अलावा क्या है?
बैंक डिक्लेरेशन के अलावा एलिगेशन है मालूम, जिनके स्टेटमेंट है फादर के, बाकी जो परेशान करते थे वो सारे एलिगेशन है मालूम। फादर के स्टेटमेंट चाहे तो आप पढ़ देता हूँ।
इनके जीजा जी हॉस्टाइल हो गए थे सर।
और ये हस्बैंड भी बहुत तंग करता था, और हस्बैंड और ये दोनों साथ रहते थे। और
हस्बैंड की बेल हो गई।
एलिगेशन बहुत है, 37।
हस्बैंड की बेल हो गई।
ये हु इज द एप्लीकेंट, हाउ इज शी कनेक्टेड? नंद है।
नंद है सर,
घर में ही थी, यही थी अकेले।
हस्बैंड के अगेंस्ट एलिगेशन नहीं है।
हस्बैंड की भी बेल
हो गई, बेल हो गई।
अच्छा,
हस्बैंड के अगेंस्ट एलिगेशन नहीं है।
नहीं, ज्यादा नहीं। केरोसिन जलाने का एलिगेशन इसी को।
यू आर द मेन अक्यूज। 302 है हीनियस ऑफेंस।
सर डिले ऑफ ट्रायल।
उस दिन हस्बैंड घर में नहीं था, जिस दिन ये इंसिडेंट।
2 साल हो गए आप।
सर 2 साल जेल में होगा सर, डेली ऑफ ट्रायल में प्रेस कर रहा हूँ सर। एक स्टेटमेंट है सर इनके जीजे जी का, मैं पढ़ के बता देता हूँ फिर आपको। जैसे
ये बैंक डिक्लेरेशन अगर सही हुआ तो
सर मैं बता दे रहा हूँ। नितिका कोमल को भी जानता था, जो मेरी साली है, मैं मजदूरी करता हूँ। कोमल की शादी आरोपी राजेंद्र के साथ वर्ष 2015 सम्मेलन में हुई थी। आरोपी राजेंद्र ने एक लड़का और एक लड़की है। दिनांक 25/11/21 की सुबह में अपने घर पर था। राजेंद्र चौधरी का फोन आया कि कोमल जल गई है, जिसे जिला अस्पताल सतना ले जाना है। जब मैं मेरे साड़ू भाई दिलीप रत्ने सभी लोग सतना अस्पताल गए, कोमल को देखे तो वह बहुत ज्यादा जली थी। उसे उतारकर अस्पताल के अंदर ले गए। इसके अलावा मुझे और कोई जानकारी नहीं। इनके जीजा जी हैं सर, इनके रियल जीजा जी।
तो ये रहते नहीं, इनको कहाँ से जानकारी होगी? 300
सर जो ये कह रहे हैं कि हस्बैंड परेशान करते थे, ऐसा कोई एविडेंस नहीं है सर ड्यूरिंग उसमें कि हमने कोई परेशान किया, ना कोई शिकायत है, ना कोई रिपोर्ट है सर। हाँ वो तो ठीक है।
नॉट 304B।
ठीक है
बैंक डिक्लेरेशन है, आपने केरोसिन ऑयल फेंक के जला दिया है।
सर फॉर अ मोमेंट हमारा एक
कुछ भी नहीं है तो भी ये डाउरी का एलिगेशन नहीं है, डिमांड नहीं है, तो भी 302 है आपके अगेंस्ट में।
अनेक्सर A4 देखने सर, एक मिनट के लिए सर। अनेक्सर A4
क्या है?
अनेक्सर A4 जो पहला बैंक डिक्लेरेशन है सर।
2 बेल में सारे कंसीडर हो चुके।
नहीं सर, बेल फर्स्ट पहली विड्रा डिस्मिस एंड डिफॉल्ट हुई है, दूसरी सेकंड विड्रा हुई है।
दोनों कंसीडर हो चुके हैं।
नो सर, पहली जो डिस्मिस एंड डिफॉल्ट हुई है वारंट ऑफ एक्सक्यूशन, और सेकंड हमने सिंपली विड्रॉ कर ली थी। उससे हमें कस्टडी पीरियड कम था सर, वो हमने विड्रॉ कर ली थी 18 नवंबर 2022 में। उसके बाद हम ये थर्ड बेल लेके आए हैं सर। अनेक्सर A4 देखेंगे सर। नाम क्या है? कोमल चौधरी। कहाँ हो? जबलपुर हॉस्पिटल में। दिन है या रात हो गई है? क्या हुआ? आग लग गई।
Counsel appearing for applicant submitted that applicant has falsely been implicated in the case. She is mother of 4 children and there is nobody to look after her young children. Full stop. It is submitted by applicant that she is in jail since 12/1/22 for about 2 years. Considering aforesaid circumstance, applicant be released on bail. Government advocate opposed the application for grant of bail. It is submitted that as per dying declaration recorded by executive magistrate, it was applicant who had burned the deceased. Allegations are under section 302 of Indian Penal Code. Full stop. Sentence is for life imprisonment. Full stop. In these circumstances, applicant may not be released on bail. Heard the counsel for the parties. Applicant is a woman who has committed an offense against another woman. Therefore, no sympathy can be another woman. Therefore, crime committed by applicant is heinous in nature. Full stop. Applicant in dying declaration is against the applicant. Applicant is main accused in the case. Considering aforesaid circumstance, application is dismissed. Trial court is directed to expedite the trial and preferably complete it within period of 6 months. If there is no progress in trial in last 6 months, then applicant will be at liberty to file repeat application for grant of bail.
सर उसको 4 मंथ कर देंगे, 4 मंथ करने सर उसको 6 मंथ को 4 मंथ कर।
कितने विटनेस हुए हैं?
अभी आउट ऑफ 17 8 विटनेस हुए सर, 2 साल में 8 विटनेस हुए।
तो बाकी 6 महीने में हो
4 महीने कर देंगे सर।
4 महीने में नहीं हो,
5 महीने कर, 5 महीने कर।
यस नेक्स्ट।
So this is my fourth bill application. Applicant is in jail since Lord 28/5/19 Lordship.
क्रिमिनल रिकॉर्ड अभी नहीं आया। बैंक से जो ऑब्जेक्शन आया उसमें ऐसा पता लगा है कि इनके खिलाफ लगभग 10 केसेस हैं लॉर्डशिप।
No Lordship.
तो वो मैं
Government
जानकारी मंगा
advocate
लेता हूँ।
appearing for state pays for time to call for criminal antecedents of applicant. There is allowed list after 1 week.
Lordship मेरा निवेदन है Lordship. I am in jail since from 5 years Lordship. Last time स्टेट ने टाइम दिया था कि एक चार्ट बनाना है इसमें Lordship. आज सर मैं ऑर्डर भी लाया हूँ सुप्रीम कोर्ट का, जो कि मेन एक्यूज है इस केस का, जो शाखा प्रबंधक है, उसकी बेल भी हो चुकी है Lordship. और जो
15 से था लॉर्डशिप।
Yes.
Sir,
the present applicant was absconding and was arrested in 2019.
Sir,
whereas the main accused was in jail since 2015.
Sir, हम
My lords have considered that point earlier and dismissed the bail application.
सर इसमें I am the
आपका रिकॉर्ड है जाने दे, देखते हैं। 10 केस हैं तो आपका बहुत लंबा रिकॉर्ड है।
सर रिकॉर्ड नहीं है वो,
आप उनसे बुला के आप भी फाइल कर दीजिए कि क्या रिकॉर्ड है आपका।
This is the repeat bail application. My lord, the order sheet of the London trial court, my lord, there is witness has not come, my lord, for my lord the statement, my lord, and honorable court has also called the report from the trial.
ये आप मेन एक्यूज्ड हैं।
Lord, ये एक ही accused है, my
एक
lord.
ही है माय लॉर्ड। 5 क्रिमिनल केस हैं जिसमें से 4 NDPS एक्ट के हैं। दिस इज 5th बेल, 4 मेरिट पर रिजेक्ट।
नहीं साहब, वो
इनका कितना रिकॉर्ड है?
my lord
5 केसेस जिसमें से 4 NDPS है।
my lord kindly see the मैंने ऑर्डर शीट फाइल के 3 एक्टल हुआ है my lord मेरा उसमें कि I have filed order
5 में से कितने में टोटल हो गए?
3 में टोटल हो गया,
2 बचे हैं।
my lord मैं बता देता हूँ my lord। ठीक है, 16 वाले में हो गया, 17 वाले में हो गया, और ये एक इस्तगासा था 110 का, वो तो खत्म हो गया my lord, और 354 2020 है, 294 का है my lord, 294 506 भी।
आप तो बता रहे हैं 4 केस NDPS के हैं।
4 केस है इंक्लूडिंग दिस my lord।
हाँ, इंक्लूडिंग
दिस my lord। 4 केस है my lord, 2016 का, एक 2017, 2 में टोटल हो गया।
रिपीटेडली NDPS के 1 kg 157 ग्राम।
Applicant has filed 5th application under section 439. कब से हैं आप जेल में?
my lord 16/3/2023 से my lord।
ज्यादा टाइम नहीं हुआ है अभी,
याद नहीं रहा,
1 साल अभी जुम्मा हो रहा है।
my lord।
Applicant has filed 5th application. Counsel, there is no change in circumstances. Applicant is having criminal antecedents of as many as 5 cases. Out of 5, 4 are under NDPS Act. Offence has been committed under Special Act and applicant is repeat offender. Full stop. Considering aforesaid circumstances, application is dismissed.
My lord, may I humbly pray, my lord. Lord has called the status report of the London trial court. Kindly see, my lord. Called by the honorable court, my lord, 28/2/2024, my lord. And I have also filed, my lord, the
अभी 1 ही साल हुआ है।
lord ये the 3 children, minor children, my lord, अब वो अगस्त में है, और ये एक my lord kindly see annexer A3, my lord, page number 38, my lord. The order and the relevant page is page number 64.
स्टेटस रिपोर्ट तो अभी आई नहीं है।
रिपोर्ट आपने मंगाया,
बट देर इज नॉट लॉन्ग डिले, प्रोसिक्यूशन नहीं आ रहा है, विटनेस नहीं आ रहे हैं, आपने तो सब कहा नहीं है।
मैंने लगाया है माय लॉर्ड, आपके आदेश हुआ था वो पिछली बार मैंने नहीं लगा पाया था, इसलिए फिर आपने बोला था कि वो मैंने फाइल किया ना, A6 इज देयर माय लॉर्ड, देयर माय लॉर्ड द एंटायर ऑर्डर शीट माय लॉर्ड,
अनेक्चर
A6 माय लॉर्ड, पेज नंबर 34 माय लॉर्ड। जान नहीं रहे, फिर उसको कोर्ट ने वारंट भी किया, फिर 22 को लगाया मतलब।
एनडीपीएस में वैसे भी थोड़ा टाइम तो लगता ही है।
There
There is no inordinate delay in conduct of trial by the prosecution.
My lord, kindly see, my lord.
Yes.
The order has been passed by my lord, a special court, my lord. And this is my lord, with due to intention, my lord, intention, my lord, made a, my lord, one एक में 400 ग्राम तो बनाया था, एक में इन्होंने बना दिया, एक में तो on the basis of the, therefore the learned trial court has, my lord, acted, my lord, may I read, my lord. साक्ष्य के विश्लेषण मकान और पर्ची में दरवाजा मोतरी सैंपल A1 A2 के मादक पदार्थ 1 किलो 10 ग्राम गंध होना पाया गया। अभियुक्त सुधा तिवारी के अभियुक्त का होना न प्रमाणित होते हुए अभियुक्त सुधा तिवारी के अभियुक्त के उक्त मादक पदार्थ गांजा जब्त किया जाना प्रमाणित नहीं पाया जाता, इसलिए अभियुक्त रेवरेंड तिवारी को सौंपा 20(2) में अवसर प्रदान अधिनियम के तहत आरोप प्रमाणित नहीं होता है। Therefore, my lord, this is the such type of, my lord, the allegation due to, my lord, intention. The police has on the basis of, my lord, memorandum that has been made accused to the present public. एक में 400 ग्राम का था, वो भी हो गया, ऑर्डर हो गया।
ये आपको क्यों एक्यूज बनाते हैं?
2016 से आफ्टर दैट, my lord, कि 2007 ईयर से मैंने इन्होंने माना, फिर ये 2023 में इन्होंने।
क्या करते हैं आप?
my lord, हाउस वाइफ है, my lord।
हाउस वाइफ है?
हाउस वाइफ है।
हाउस वाइफ की वो तो 5-5 केस पुलिस नहीं लगाएगी।
my lord, ये इनका हमारे हस्बैंड से इनका पुराना विवाद था, my lord। And my lord, and under these circumstances, the honorable learned trial special court has, my lord, considered and found that, my lord, that there is, my lord, the intensity, my lord, and that has been acquitted by, my lord, the learned trial. Clean acquittal has been given.
क्या लिखा है? Fifth bail application, no inordinate delay. Applicant is repeat offender under Special Act of NDP. Full stop. Considering aforesaid circumstance, application is dismissed. Trial court is directed to expedite the trial.
आपने किया तो, my lord, I am simply withdrawing, my lord. अब 22/4 के बाद अगर 22/4 को लगा है तो I am बाद रिपोर्ट। I am withdrawing.
Applicant is at liberty to file repeat application after examination of independent Caesar witnesses in the case.
The last date of hearing, that is 1/3/24. Honorable Court has called the status report from the trial court.
Code 2467. कब से आप जेल में?
हम हैं 6/4/22 से। So my early application was dismissed on merits on 21/11/23.
1 year.
ये स्टेटस रिपोर्ट आ गई है सर, देखने क्या, क्योंकि इसमें
दिस इज फिफ्थ बेल, फोर्थ डिटेल्ड मेरिट पर रिजेक्ट हुई, जिसमें 1 क्रिमिनल केस सेम नेचर का इनके खिलाफ। फोर्थ बेल 21/11/23 का ऑर्डर।
ये तो उन्होंने बोला है कि प्रोसिक्यूशन नहीं रख पा रहा है विटनेसेस को प्रेजेंट इन कोर्ट। 1 साल हो गया जेल।
2 साल दिलाएंगे सर, 6/4/22 से सर 2 साल।
2 साल। Applicant has filed fifth application, police station offences. Counsel for applicant submitted that offences are not very serious in nature. Applicant is innocent, falsely implicated. He is in jail since last 2 years. Full stop. There is delay in prosecution. there is delay on part of prosecution to conduct the trial. In these circumstances, applicant be released on bail. Status report is received from the trial court. Trial court has sent a comment that prosecution is not keeping the witnesses present in the case. Therefore, there is not much progress in trial. कितना पैसा था?
9 लाख रुपए बेल दिया आपने को 21 को।
कितना जमा कर देंगे आप?
19,50,000 का आया सर इसमें।
क्या जमा हो चुका है?
ना सर, ये को 21 का जो बेल ऑर्डर है, माय लॉर्ड हैज ग्रांटेड बेल टू को एक्यूज, जिसके खाते में ये पैसा आता था उस लेडी
फोर्थ बेल का पैरा 3 पढ़ रहा हूँ माला।
Yes.
Learned government advocate appearing for the state opposed the applicant for grant of bail and submitted that applicant is the main accused in the case. Though amount has been deposited in account of but same has been withdrawn by applicant through ATM card of co-accused. ATM card of co-accused has been seized from applicant. Total amount of 90 lakhs has been taken by applicant and co-accused persons. Applicant impersonated himself to be ADM of BHEL Bhopal and promised to secure job of complainant and collected money. It is further submitted that one more criminal case of similar nature has been registered against applicant at Wind. 18 ATM cards of co-accused have been seized from applicant.
Yes, कितना पैसा
applicant is having
19 lakhs का allegation है.
ये तो उस लेडी के खाते में जाता था, who has granted bail, केवल उसका
बाद
मेमो
में ये आया कि ATM से ने ड्रा किया है 18
Yes.
ATM।
ये तो हाउस वाइफ है, लेडी का तो कोई रोल नहीं है, रोल तो
सर,
आपको
इसके खाते में पैसे आए हैं सब इस लेडी की। इस लेडी ने ये कहा कि ये मेरे खाते से पैसे निकालते थे, कुछ पैसे मुझे दे देते थे उसमें से।
इन केस
अरे सर मुझे पूरा कर लेने दें।
Yes.
पहली बार ये शिकायत नहीं, हर बार रहती है।
Yes,
ठीक
yes.
है, मोस्ट सीनियर आप, यू शुड
Don't argue with
भाई,
me.
सर
मैंने
हर
कुछ
बीच में क्यों बोलते हैं आप?
अरे मैंने क्या बोला भाई?
You
क्या
are
नहीं बोला?
नहीं बोला, कुछ नहीं
you are also senior advocate.
सर
Don't behave
जब
like
ये
this.
बोलते तो हम चुप रहते हैं।
नहीं, वो भी चुप रहते हैं जब आप बोलते हैं।
मेरा कहना ये सर कि वो उसका पार्ट भी जिसको कोई किसको बेल मिली है लगभग सिमिलर है, पैसे
Similar
उसी
नहीं
के
है,
खाते।
she is a housewife, 35 years
सर
old.
ये कोई
She was pregnant.
प्रोसिक्यूशन का अपना ऐसा केस है कि इसके खाते में वो पैसे आते थे, बाद में मेमोरेंडम देना तो बहुत इजी, दैट इज द इनएडमिसिबल पीस ऑफ एविडेंस कि मेरे से ले गए।
ये पैसे कहाँ से आते थे?
ये जिन लोगों को प्रॉमिस किया था सिक्योर जॉब के लिए, उन लोगों ने।
और किसने प्रॉमिस किया था?
ये मैंने एक्यूज ये हमारा टोटल
Applicant.
इन्हीं ने प्रॉमिस किया
कितने
जॉब
पैसे-
के लिए।
कितने पैसे जमा कराएंगे?
19 लाख रुपए का एलिगेशन है, अब मैं पूछ लेता हूँ ना, इंस्ट्रक्शन के मैं बोल दूंगा, क्या हो जाएगी, फिर रिकॉलिंग की नौबत आती है।
तो विड्रॉ कर लीजिए।
नहीं इसको नेक्स्ट वीक आफ्टर होली वेकेशन रख लेते, मीन भाई या फिर
Council-
पास ओवर में रख लें तो पूछ लेता हूँ।
Counsel for applicant prays for time after 2 weeks.
गुड
Yes.
My lord, this is sixth bail application. The applicant is in jail since 27/10/2020. On 28th of February 2024, my lord was pleased to call for the status report from the trial court, my lord. As per my information, my lord, 12 witnesses have been examined till 13th of March 2024.
How many?
24, 24 witnesses, 12 have been examined. And if my lord may kindly appreciate the order that I have placed at page number 18. My lord was pleased, this is order dated 9th of August 2023, wherein my lord was pleased to grant me liberty. Para number 6, considering the long period of custody, trial court is directed to expedite the trial and preferably complete it within a period of 6 months. If trial has not completed within a aforesaid period, then applicant will be at liberty to file a repeat application for grant of bail.
Yes, state
मतलब
आपने सप्लीमेंट्री चार्जशीट फाइल करी है एंड यू हैव फाइल्ड एन एप्लीकेशन फॉर री एग्जामिनेशन ऑफ सम ऑफ द विटनेसेस, सो देयर इज डिले ऑन बिकॉज ऑफ यू।
मालट लेकिन एलिगेशन इनके खिलाफ मालट 3 जैसे 6th बेल मालट और 13 क्रिमिनल केस हैं इनके,
ये 3.5 साल से जेल में है।
जी
13 केस इनके खिलाफ क्रिमिनल केस,
I
13
may,
केस करे।
I apologize to interrupt my learned senior, my lord. In fact, I could not place it on record, but there is an order. The trial court has mentioned 18/1/2023. The Honorable Supreme Court has directed to expedite the trial, and even after 1 year, the trial could not be concluded. Though the date has only been mentioned in the order sheet, if my lord may permit, I may hand over the order sheet. 18/1/2023 में ट्रायल कोर्ट खुद लिख रहा है कि देयर इज अ डायरेक्शन ऑफ
विटनेसेस आर नॉट कमिंग अप।
मालूम
खाली किसी ऑर्डर में ये नहीं आया है, 13 केस बाद में रिकॉर्ड आया है, 13 केस है। श्रीपद पाठक पिता ने
क्या ऑफेंसेस हैं?
ये 147, 148, 294 वाला, फिर 307 का है मालट सेकंड, और फिर 107 का है, फिर 294 का है मालट, फिर 307 का है, फिर 307 का है, फिर 302 का है, एक 454 2020।
ये तो सारे ऑफेंस सीरियस हैं।
सर ये मोर और लेस द कंप्लेनेंट आर इंटरचेंजिंग। वी आर हैविंग अ फैमिली डिस्प्यूट, वी आर नॉट डिस्प्यूटिंग, आई एम नॉट डिस्प्यूटिंग इट। they are the complainant is the neighbor, और एक घर के बाद रहते हैं, and we both of them, in fact the applicant have also lodged cases against the complainant.
302
वो बोलता
सीरियस ऑफेंस है, हीनियस है।
क्योंकि जब बेल रिजेक्ट हुई थी महाराज, उस समय आपने डायरेक्शन दिए थे कि क्रिमिनल रिकॉर्ड बुलाएं, तब ये क्रिमिनल रिकॉर्ड बाद में आया।
the last offense that has been registered is this itself,
So let him appear before police station twice.
मालूम
Applicant has filed 6th application under section 439 police station offences. Counsel for applicant submitted that earlier bail application filed by applicant was dismissed by this court on 9/8/23. Direction was given to conclude the trial within period of 6 months. It is submitted that applicant is in jail since 27/10/23 for more than 3.5 years. It is submitted that in view of incarceration of applicant, status report was called. Full stop. It is submitted that there is delay in trial. Applicant be released on bail. Government advocate opposed and submitted that applicant is having criminal antecedents and as many as 13 cases are registered against him. Full stop. Most of the offences committed by applicant are serious and heinous in nature. In these circumstances, he may not be released on bail. Heard the counsel for the parties and perused the status report which is received from the trial court. As per said status report, witnesses are not appearing before court, and prosecution has also filed supplementary charge sheet and had made a request for re-examination of prosecution witnesses. Bailable warrants were issued to witnesses, but despite that, they are not appearing before court for their examination. आपने भी प्रति परीक्षण का अवसर लिया है।
एक मिनट लिया। I'm not.
Applicant has also taken time for cross-examination of witnesses. Full stop. Considering the fact that applicant is in jail since last 3.5 years, कितने witness examine हुए?
12.
And only 12 witnesses are examined in the case. Total कितने?
24.
Out of 24 witnesses. Trial court has also stated in status report that witnesses are not turning up to give evidence. Considering the period of custody and delay in trial, application is allowed with following condition. Applicant will mark his presence before local police station twice every month. Applicant will not seek unnecessary adjournments in the case for cross-examination of witnesses and will appear before trial court on all dates when applicant is required. 50,000, two sureties.
HON'BLE.
Offenses.
325, 34.
Yes.
Valuable.
2 years conviction, applicant in jail.
Allowed.
HON'BLE.
Released on bail. Short-term sentence.
1 year conviction.
Allowed. Yes, next.
Thus, we have filed this
4 year.
4 year
Lokayut.
Lokayut.
PC Act.
So who is appearing? Yes, you are appearing.
Let's appear on
Okay.
Record is called.
No, my lord. This is the first hearing. Records abhi aana baki hai.
Records. Registry is directed to
One more
call
humble
for-
submission, Your
Call
Lordship.
for records after 4 weeks.
Your name may be reflected.
One more humble submission. my
Yes.
lord. My lords, the applicant is 65 years of age, a cancer survivor. हम humble urge करते हैं, my lord. If my lords may kindly see annexure A3.
आपने कोई डॉक्यूमेंट फाइल किया है?
Yes,
इसमें
my
तो
lord.
बहुत सारे लोग हैं. How many people are there? कितने accused हैं?
Only one, my lord. Mandhati.
Only one.
Mandhati Kumar, my lords.
He is 64.
Now it's 65, my lords.
What document you have filed?
My lords, may kindly see annexure A3, page 69.
Yes.
My lords, इसमें impression और diagnosis में एक लिखा हुआ है, well to moderately differentiated. I am not good in medical terms, my lords, मतलब pronunciation of medical terms. Invasive squamous carcinoma. My lords, ये इनको
What is
operate,
the stage?
my lords, इनका operation हुआ है, my lords, and
Yes, state.
Lords, I do not have a file. My name was not to blame.
कब से हैं आप जेल में?
from 29th, my lord, from 29th of February, my lord.
February.
It's 18 days almost, my lord. What my humble is, my lord.
Appellant has filed this appeal against judgment sentence. Counsel appearing for appellant submitted that appellant is aged about 64 years and is suffering from cancer. Full stop. In these circumstances, sentence be suspended and he be released on bail. Government counsel appearing for loci prays for time. Registry is directed to call for records. Full stop. Considered IA number 6421 of 24, application for suspension of sentence. Limited short-term sentence has been imposed upon the appellant. He is in jail since last 1 month and aged about 65 years and suffering from cancer. In these circumstances, application for suspension of sentence is appellant be released on bail, 50,000 one surety.
One
List for admission along with records.
highly obliged.
Abhijit Awasthi may be reflected.
Abhijit Awasthi.
Item number 7.
Raise for withdrawal dismissed. Any liberty? Forty-one.
5 years.
None appears adjourned. Registry is directed to call for records.
This is what issued on the last date and this is returned unserved.
No, this is 138.
This is CR.
So serve it on respondent.
सर उनके खिलाफ क्या बिलीगल वारंट निकला हुआ है तो वो दे नहीं है बहुत बार ट्राई करा है हमने ऑर्डर शीट भी फाइल करा हुआ है
इनके अगेंस्ट बिलेबल वारंट
जो रिस्पोंडेंट है निशा लालवानी
कितना आपने डिपॉजिट कर दिया? डिपॉजिट कितने का चेक है? 25-30% जमा कर दीजिए.
अराउंड
3,000.
सर इसमें जो नोटिस इशू हुआ था वो
कितना? 3 लाख
75
71,000 करीब 75,000. Fresh notices be issued to respondent for service of notice. आप जेल में?
1 month liberty was granted for surrender of that.
Surrender कर दीजिए आप. Applicant is directed to surrender before court and go to jail. Yes.
70,000 rupees.
75,000 जमा कर रहे हैं ना? जमा कर दीजिए, नेक्स्ट वीक लगा देते हैं. List next week for consideration. And surrender. Either surrender or deposit.
Yes, deposit.
Yes. Next week.
ये लोकायुक्त का
Last date of it.
But there is an application for suspension of conviction. We'll argue that matter out. Today, Shri Abhijit Avasthi is at
File your reply.
minutes. Minutes will file.
Counsel appearing for Lokayuk prays for 2 weeks.
2 weeks time.
Time as last opportunity to file reply to application for staying suspension. Prayer is allowed after 2 weeks.
And week commencing.
Week commencing.
Great praise the Lord. For this first application, in the last date of hearing, the criminal record of the applicant was directed to be called.
Yes, state.
माल उड़ा गया है।
कितने कितने रिकॉर्ड?
ये लॉट से 45 जो है वो सत्यम जायसवाल
वो तो विड्रॉ हो गई सर, विड्रॉ। इसी में रमेश की है वो, आई एम प्रेसिंग दैट एप्लीकेशन।
नंबर 2
Ramesh. He was the driver, my lord, of offending vehicle, and admittedly, my lord, he was, my lord, directed by the owner, my lord, the other कोई persons, my lord, hired that vehicle. पैरा 32 में आया है।
तो आपसे तो अभी मिला है, कितना टाइम हो गया आपको जेल में?
सर अभी ये 8/11/14 से 19/3/15 तक पहले रहा है सर। अभी 26/9/22 से जेल में। कोई क्रिमिनल रिकॉर्ड नहीं है, इन्फॉर्मेशन, my lord. Admittedly, my lord, he was the driver of the offending vehicle. He was an illiterate person, my lord.
कितना है इसमें, कितना ड्रग्स मिले?
300 बॉटल, my lord, कप सिरप है। 4 गाड़ी से ऑफेंडिंग व्हीकल से मिला है। उसमें 4 कोई कुछ बैठे हुए थे। वो, my lord, हायर्ड व्हीकल। वो जो व्हीकल है वो सब PW7 का, पुलिस ने उनको मुलजिम नहीं बनाया। उनको he has been made to the prosecution witness. He has clearly deposed, my lord, कि उसने हायर किया था और इसको मैंने ड्राइवर के रूप में भेजा। मेरा 32 में आया है। पर apparently, my lord, there is no FSR. माल जमा पर्ची भी नहीं है सर। PW5 ने पैरा 14 में कहा है सर, माल जमा करने की कोई पर्ची नहीं। And my lord, the person, my lord, who was directed to convey the information for, my lord, DSP, he has clearly stated कि वो DSP साहब उसमें मौजूद थे। बट पूरी कार्रवाई में आया है कि वो मुख्यालय के बाहर थे।
कितना टाइम हो गया जेल में?
सर ये 26/9/22 से अभी है सर। अब इसके पहले सर लगभग 3 महीने पहले रहा, 4 महीने।
तो ज्यादा टाइम नहीं हुआ है, 10 साल है।
फर्स्ट ऑफेंडर है सर।
3 साल के बाद कंसिडर
जो रोल है सर, जो इसका रोल है ड्राइवर, my lord.
यस,
काइंडली अप्रिशिएट रोल ऑफ दिस एप्लीकेंट विल बी ड्राइवर, my lord.
तो ड्राइवर है तो ड्राइवर को तो पता रहता है गाड़ी में क्या भरा है।
तो मालिक की गाड़ी थी सर। ही वाज नॉट एक्टेड अपॉन डिक्टेट ऑफ, my lord, the owner.
आप माइनर है क्या?
नहीं, he has not acted upon, my lord, the dictate of the owner, my lord. माइनर तो
व्हाट डिक्टेट? इलीगल काम कर रहे हैं।
हाँ, ये सर 23 में कंडीशन, my lord. पैरा 23 मेरिट, my lord.
मेरिट में क्या है आपका?
मेरिट में मेरा पहला सबमिशन तो ये है, my lord, कि the applicant, my lord, the cup syrup was, my lord, found in the vehicle. Therefore, my lord, he cannot be said to be in conscious possession, my lord, contraband.
तो कैसे होगा? जब जेब में रखा होगा जब ही होगा।
The last date of hearing
300 बॉटल्स हैं आपके ट्रक में। यू आर ड्राइवर, यू आर इन कॉन्शियस पोजीशन।
ट्रक नहीं सर,
बोलेरो गाड़ी
है सर।
और 2 बोरियों में, एक में 230 है, एक में 70 बोतल है, 300 है टोटल।
फिर तो और ज्यादा कॉन्शियस पोजीशन है आपका। ट्रक होता तो समझ में भी आता है, इतना बड़ा है तो आपको पता नहीं चला।
बोरियों में है तो बात नॉट सपोज।
यस, बाकी आपको और क्या कहना है? और कोई रिलेटेड जो
कोई क्रिमिनल रिकॉर्ड नहीं सर।
इनका एक क्रिमिनल रिकॉर्ड है, रमेश का 294, 325 का एक है। और इनका जो कृष्णदेव है, इनका एक NDPS का 2013 का है, जी 2014 का सेम धारा में।
Appellants has filed.
My lord, withdrawal.
Counsel for appellants prays for withdrawal of application for suspension of sentence. Prayer is allowed. Application is dismissed as withdrawn.
Any liberty.
3 साल बाद आई।
My lord. क्या मीन दिस?
Appellants may file repeat application after they spend substantive part of sentence in jail and case is not reached in final hearing list. है? हाँ, सबका
3 साल का मतलब 3 साल के लिए।
हाँ, यस, 3 years कर दीजिए।
So 383 days का delay है लॉर्डशिप। The appeal filed के थ्रू फाइल हुई है लॉर्डशिप इसमें।
Yes, you want to file reply to their application.
लॉर्डशिप इनने ऑब्जेक्शन फाइल किया, 374(2) का रिप्लाई दिया है, बट इनने सेक्शन 5 का कोई रिप्लाई फाइल नहीं किया।
Section 5 तो आपको, I'll allow this section 5.
It can be lordship.
You file reply to suspension of sentence.
That has been filed lordship. It has already been filed.
उसमें
Already filed. You are ready with the matter today?
लॉर्डशिप इसमें
आप तैयार हैं केस में बहस के लिए?
सर सस्पेंशन पे
You are ready?
लॉर्डशिप
Yes. Yes, respondent, you are also ready.
Yes, yes.
लॉर्डशिप 10 ईयर का कन्विक्शन है और जो मेन सजा है वो पूरी हो गई है, सिर्फ पनिशमेंट पे अभी जेल में है लॉर्डशिप। वो सॉरी वो फाइन पे लॉर्डशिप, फाइन डिपॉजिट नहीं किया है लॉर्डशिप।
कब से आप 10 साल हो गए आपको जेल में?
18-12-14 से 10-12-14 तक थे जेल में, फिर
18-12-14
से 10-12-14 ड्यूरिंग ट्रायल जेल में थे।
और 18-12 से 10-12
18-12-14 से 10-12-19
5 साल। यस।
और 6-3-20 से अभी जेल में लॉर्डशिप।
4 साल ये हो गए आपको, अबाउट 9 years हो चुके।
5 to 6-7 years.
Appellant has filed application IA number so and so for condonation of delay and IA number so and so for suspension of sentence. Counsel appearing for appellant submitted that he is in jail for about 9 years and 9 years full stop. There is no likelihood of hearing of appeal in near future. Appeal is preferred in year 2024. It is further submitted. ये तो फाइन अमाउंट तो आपको डिपॉजिट करना ही पड़ेगा। कितना है फाइन अमाउंट?
लॉर्डशिप इसमें 7 लाख जमा कर दिया था, टोटल 22,78,000 का एलिगेशन है लॉर्डशिप।
It has to be deposited lordship prior to allowing this application seeking for suspension of sentence.
So
Because this is
sentence
fine
also
amount
include
also.
fine.
Fine amount lordship that is to be deposited first, even prior to filing this appeal also. And there is
ऐसा
no
कुछ है क्या?
application.
Is there anything provided in act? इसी एक्ट में ऐसा कुछ है क्या कि फाइन अमाउंट आपको डिपॉजिट?
There is no application as such also seeking for exemption from that fine amount to be deposited.
No, he has filed application for suspension of sentence.
That is the.
So sentence include fine also. Court can suspend it. 9 साल तो इनको हो ही गए हैं जेल।
Lordship to my.
After 9 years, he will not be in a position to deposit fine.
That is their lordship होते हैं।
बाहर होते तो कर भी देते।
7 लाख इन्हें डिपॉजिट कर भी दिए हैं लॉर्डशिप उसमें 22 लाख में से।
Elevative lordship.
In 24, appeal is of year 23. Full stop. It is submitted that looking to long period of incarceration of appeal, appellant sentence be suspended and appellant be released on bail. Counsel appearing for CBI opposed the prayer for suspension of sentence. ऊपर delay condone कर दीजिए for reasons stated in application. And submitted that appellant has not deposited the fine amount, therefore sentence may not be suspended. Heard the counsel for the parties. Sentence includes fine also. Full stop. Appellant is in jail for 9 years. He is convicted for period of 10 years. After such incarceration, it may not be possible for appellant to deposit the fine. Considering aforesaid circumstance, sentence dated so and so and fine is suspended. Appellant be released on bail. 50,000 2 sureties, 1 lakh 2 sureties. Admitted for hearing.
For next.
Yes.
Next week.
As prayed adjourned after 1 week.
49.
There is an IA for suspension of conviction, my lords. I am paying
the reply. It is already suspended.
आप कौन है?
For Lokaयुक्त Malaj.
अच्छा. Counsel appearing for Lokaयुक्त prays for time to file reply to application for suspension of conviction. Prayer is allowed. कितना time चाहिए?
4 weeks time will be granted.
Last opportunity to file reply within period of 4 weeks. Week commencing.
उसको objection file.
Government advocate prays for 1 week time.
वो पहले भी आपने दी है.
Last opportunity to file objection.
What is the appeal against the conviction of under section 8C of the NDPS Act, Lordship? The 7 green plant of the ganja seized from the property of the present applicant.
7 green plants.
Yes, 2 years conviction is there, Lordship. Is the behind the bars in date of
Short term sentence, 7 green plants was found in house.
in the field of
In agriculture field, it is submitted that plants may also grow sporadically in the field. कोई आपका criminal antecedent?
कोई नहीं.
Appellant does not have any criminal antecedent. Short fixed term sentence. Government advocate opposed. Offense is serious. Considering totality of facts and circumstance, IAS is allowed since suspended. Appellant be released on bail. Admitted for final hearing. Record है?
I'm so glad. I prefer
certified. As prayed adjourned after 4 weeks.
In this case, total 6 accused. 3 लोगों की already. In this case, as per prosecution case, Vyar Singh, appealant number 1 and appealant number 3 is a similar case of Pushpa and Pooja Violet, लाठी से मारने का allegation. And Rakesh Dangi, appealant number 5.
कितना? What is sentence?
5 years.
226 वर्ग
Same
और यंग बॉय है और ऑलरेडी काउंटर केस में सजा हुई है वायलेट सिमिलर एक्सीडेंट.
Your underlying part.
So 2 connected appeal है CRA 1927.
Yes.
And CRA 2144.
Yes.
7 year conviction है सर. दीपक जो है 1927. इसमें allegation ये है कि he was armed with baka and caused the injury to the complainant. Complainant sustained all the injuries listed at wounds. PW8 Dr. HR.
Complainant is hostile?
नहीं.
Not hostile. अभी तो आई विटनेस रिलाई करेंगे.
सर मैं बोल रहा था कोई फ्रैक्चर नहीं है. 13 तारीख को एडमिट हुआ, 14 तारीख को डिस्चार्ज हो गया. डॉक्टर कहते हैं कि कोई फ्रैक्चर नहीं है.
कहाँ पे चोट है?
सिर में.
भाई
भाग गया. इलाज ही नहीं करवाना था. ड्रिंक किया हुआ था वो. ये प्रोसिक्यूशन गई. एडमिट भी किया है कि ड्रिंक किया हुआ था. मैं
How much is sentence?
7 years.
7 years. 7 years.
दीपक पहले 9 महीने पहले रहा था सर और अभी जनवरी से
फरार था.
नहीं 9 महीने पहले ट्रायल में रहा था जेल में और अभी जनवरी से
9 महीने रहा
जी. करीब 1 साल हो गया. 1 साल.
1 year.
जी.
Out of 7. और आपको कितना टाइम हो गया?
अच्छा ये नहीं है आपके?
There is no.
आइए नहीं है आपके. ये तो सिर्फ लिंक है इसमें.
सस्पेंशन भी है.
सस्पेंशन
लगा था उसमें
आज लगा नहीं है बट सस्पेंशन इज फाइल्ड. 307 ऑफेंस तो सीरियस है. आप कितना टाइम रहे हैं जेल में?
1 महीने 17 दिन पहले. ये
1 month 26 days. थोड़ा टाइम हो जाए.
Sir, all the injuries are teacher Miller. All the injuries. There are 3 injured person. All are there.
ये स्टेट
7 ईयर मतलब है अभी एक
पढ़िए,
महीने
डॉक्टर
कुछ
का
रहे।
एविडेंस पढ़िए।
PW8
अभी तो इसमें रिकॉर्ड नहीं आया।
आगे तो पैरा 25 जजमेंट का पढ़ जजमेंट
पैरा 25
5 जी। आहत कृष्ण कुमार PW मैरिड।
हाँ यस
जी। आहत कृष्ण कुमार PW2 को उपचार के दौरान उसके सिर तथा छाती का एक्सरे कराया है। एक्सरे डॉक्टर यशवंत जारे रेडियोलॉजिस्ट थे, उनके द्वारा एक्सरे रिपोर्ट लिखी गई थी, जिसमें एक्सरे लिए जाने के भाग में कोई अस्थिभंग नहीं था। जो एक्सरे रिपोर्ट प्रदर्श P16 है। यशवंत मेडिकल कॉलेज जबलपुर में एक्सरे विभाग में कार्यरत थे, उनके हस्ताक्षर पर। इसके बाद सर पैरा 26 डॉक्टर BYR यादव PW7 ने अपने प्रतिपरीक्षण के दौरान यह स्वीकार किया है कि आहत को आई सभी चोटें फटी हुई थी। यह भी स्वीकार किया है कि आहत को आई चोटें गिरने से आ सकती हैं। यह भी स्वीकार किया है कि आहत को आई चोटों को गहराई उल्लेख नहीं है। यह भी स्वीकार किया है कि प्रदर्श P14 में डॉक्टरों के द्वारा चोटों के संबंध में आहत के अस्पताल से भाग जाने के कारण अभिमत न देना व्यक्त किया है। यह भी स्वीकार किया है कि क्वेरी रिपोर्ट में दी गई रिपोर्ट के अनुसार यह नहीं कहा जा सकता कि आहत को भेजे गए बकास से चोट आना संभव है या नहीं। फिर सर डार्क लाइन में है। यह भी स्वीकार किया है कि आहत
Appellant has filed this appeal under section so and so against judgment and conviction dated so and so. Counsel appearing for appellant submitted that there was no examination of the injuries which was suffered by the complainant. Full stop. It is submitted that complainant suffered all simple injuries and he left the hospital without any treatment. It is further submitted that doctor has not given any opinion regarding the nature of injuries. Full stop. It is submitted that considering the nature of injuries and taking into account period of incarceration, appellant be released on bail. Government advocate opposed and submitted that appellant has assaulted the victim, has assaulted the complainant. Full stop. Why 307?
हेड इंजरी के कारण।
तो हेड इंजरी में क्या है? डॉक्टर का तो कोई ओपिनियन
कोई ओपिनियन।
देन हाउ कम 307?
जो कि सिर में है तो 300।
ये स्टेट सिर,
तो सिर की चोट के कारण ही मतलब
नहीं तो सर में है तो डेंजरस टू लाइफ है या नहीं है? इन
डेंजरस टू लाइफ तो नहीं आया है।
Government advocate opposed the application. Heard the counsel for the parties considering fixed short-term sentence and facts and circumstances of the case and also taking into account the incarceration of appellant.
ये लगा हुआ है में सस्पेंशन।
Yes, yes. ये नंबर डाल दीजिए।
जी जी।
55. दोनों।
Number 55.
Sir, I am praying for next week.
As prayed at June 1 week, 2 weeks. अपील है 4 weeks कर देते हैं, 4 weeks.
Objection not filed, ma'am.
My lord, I invite your lordships in this matter, order dated 11/3/24. Passed by lordships while dealing with the bail application of co-accused person.
He was allowed.
Number 3
was allowed.
Now, lordships had dealt with the matter, and it is submitted that injury, as the objector has opposed the application, offence is not dependent on the injury but the intention. इसमें हमारे खिलाफ एलिगेशन नंबर 1 ने उसके सिर पे शार्प कटिंग वेपन मारा. There is no fracture over the head, the fracture is over the hand. और जो शार्प कटिंग वेपन की बात करते हैं कि वहां मारा, वहां पे लैसेरेटेड चोट है. Kindly see to the evidence of the Dr. PW11.
You are.
The application has been filed by 2 persons, Umesh Pandey and Kamlesh.
दोनों की कोई इंजरी नहीं है.
कोई चोट, फ्रैक्चर सिर पे, सिर के ऊपर सिंपल हर्ट है. हाथ पे फ्रैक्चर कहते हैं।
हाँ, हाथ में ये फ्रैक्चर बताया मैंने 52 पैरा 52 में आए हैं डॉक्टर PW11 डॉक्टर अखिलेश
सर में कोई फ्रैक्चर नहीं?
नहीं सर में नहीं।
Appellant has filed IA number 6817 of 24 for grant of bail to appellant number 2 and 3.
1 and 2, Manoj.
1 and 2. It is submitted that appellant number 3 is enlarged on bail while order dated 11. Sentence was suspended and enlarged on bail while order dated so and so. It is further submitted that complainant has received fracture in his hand. Allegations are made that appellant has used sharp cutting weapon for causing injury on head of the complainant. However, no incisive wound was found on head, and doctor has also not opined that there was any fracture on head or injury was dangerous to life. Full stop. Government advocate opposed the application for suspension of sentence and grant of bail. Considering the facts of the case and short fixed term sentence of 7 years, application and also taking into account circumstances of case, application IA number so and so for suspension of sentence is allowed. Appellant be released on bail on deposit of fine amount 50,000 170. Yes. 58. Yes, yes.
आप object करिए।
Appellant is convicted under
Objector के लिए डाल देना. Yes.
Lordship, appellant is convicted under section 452, RI for 5 years and 392 RI for 7 years, my lord. Out of 7 years, my lord, he served jail sentence about 1 year and 4 to 5 months, my lord. During trial, he was on bail, my lord.
कितना रिकॉर्ड है आपका?
एक भी रिकॉर्ड नहीं है साहब।
ये स्टेट
रिकॉर्ड तो नहीं है माय लॉर्ड, मगर केस अगर देखें तो घर में घुस के अकेली लेडी को पुत्र से महापुत्र को मारने की धमकी देकर 4 कंगन सोने के, 2 चैन, 1 जोड़ टॉप्स
मंगल।
Yes, my lord. Identification memo is exhibit P4, my lord. And identification of ornament is exhibit P10.
Records are not available. Registry is directed to call for the records after 4 weeks.
लॉर्डशिप लोकल मैटर है, मेरा निवेदन है होली की बात लगा दें।
List next week. Registry is directed to send records in court.
Oblige.
इसमें ऑब्जेक्शन आना है।
और कितना टाइम चाहिए?
1 हफ्ता।
Days for 1 week time to file objection allowed.
376(2).
सर सेकंड बेल है सर फॉर डिसमिस आज मेरिट सर। इसमें डायरेक्शन था कि आफ्टर रिपीट आफ्टर 6 मंथ सर, और इसमें हुआ ये कि सर 2 स्टेटमेंट हो गए सर। मजिस्ट्रेट साहब का ट्रायल चल रही है, सीजर विटनेस उस ट्रायल हो गया और कंप्लेंट आल्सो एग्जाम बिफोर द कोर्ट, और उसने बोला कि हम CCTV फुटेज में हमको दिखा दिया था, पहचान करा दिया, पहचान पलट होने के पहले।
तो CCTV फुटेज तो आपका प्राइमरी
नहीं, उससे और आगे लिखा मुझे थाने में 23/11/23 को मुझे दिखाया गया था।
कितने रिकॉर्ड्स हैं आपके?
कोई रिकॉर्ड नहीं सर, फर्स्ट केस।
ये स्टेट
और पूरा सामान उसका बरामद हो गए।
कोई रिकॉर्ड है?
सर रिकॉर्ड नहीं है सर, लेकिन CCTV में तो इनका आया सर। उसी
कंप्लेनेंट हैज बीन एग्जामिन्ड।
हाँ, एग्जामिन हुआ सर, मेरे पास काफी सर।
अभी
एप्लीकेंट हैज फाइल्ड रिपीट एप्लीकेशन अंडर सेक्शन 439 ऑफ कोड ऑफ सेकंड एप्लीकेशन कर देना पुलिस स्टेशन ऑफेंसेस। Counsel appearing for applicant submitted that applicant is innocent and has falsely been implicated. It is further submitted that applicant does not have any criminal antecedents and first time offender. Full stop. Complainant has already been examined in court and now there is no chances that applicant will be able to tamper with evidence. He is in jail since 22/11/23. Government advocate opposed the application for grant of bail. Heard the counsel for the parties. Applicant is in jail for some time. Complainant has been examined and now there is no chances that applicant will be able to tamper with evidence. Applicant is first time offender and a young man aged about 27 years. Considering aforesaid circumstance, allowed 50,000, one surety. Yes, any records?
21 केस.
Yes, after independent witnesses.
Yes, my lord. सीधे witness है.
Examined.
Yes, my lord.
Hostile.
Hostile, my lord.
Yes, state.
Hostile.
Application is allowed on condition that applicant will mark his presence before local police station twice every month. If applicant is found involved in any other offence in future and same is reported to trial court, then trial court shall arrest the applicant and send him to jail immediately. Bail order granted by this court shall stand automatically cancelled. Applicant will regularly attend the trial and will not seek unnecessary adjournments. With aforesaid condition, bail application is allowed. Applicant be released on bail. For Caesar witnesses are hostile. Examined and they are hostile. Government advocate opposed on grounds that applicant is having criminal antecedents. There are 21 cases against him.
Hello, sir. Today, just in the morning time, I have received this application also, which has been filed today. So I'm just praying a week time to file the reply in this case.
No,
also,
it can be
because-
kept on Thursday, sir. It's a case where, a typical case where the bribe giver and the bribe taker both have been made accused.
So both are accused?
They would not be. They would not be. Provided.
We'll hear it.
Sir, so Thursday रख लें sir आप.
Yes, how much time?
I will try to file
Thursday.
but, because it has to be filed from
It can
headquarter
be.
Delhi also. So I will try to file it by Thursday, but I cannot commit.
Thursday रख लें.
Let it be after 1 week, Tuesday.
Sir, can it be Thursday, sir? The man is lying sick, so that is the reason.
What is his age?
He is aged 56 years, but an offence maximum sentence
So
of
try
whatever
to
is.
file it. If you don't file
If they
it,
don't
then
file it,
I will try, Lord. Sir. I will try.
Lordship में grant.
So when you want this?
This Thursday.
This Thursday will be too short a time.
नहीं सर, अब कॉपी तो आपको सर्व कर दी.
अभी
बेल
नहीं,
एप्लीकेशन अगर आप लेते हैं.
Today morning only I have received copy, Lord,
How
because
can
it
it
was
be?
given to some other counsel.
It was given to Mr. Pankaj Dubey, the standing counsel for CBI.
So he will take some time to receive comments from CBI.
Sir, I'll bow down to it, Lordship. If Lordship are just kind enough to kindly, I won't press. If it doesn't come, I'll not press.
If you are not able to find,
They
then
may
I
let
will
him.
let you.
Lordship would grant them time.
I will try, Lord.
Counsel appearing for CBI prays for time to file reply to application. 1 week time for filing reply. Learned senior counsel appearing for applicant presses that case be list on Thursday. As applicant is what?
My lord, they are the persons against they
So
against
he's 27 years.
No, one is 27, the other one is 56, sir. He's lying. I filed a document that he's.
Who is ill?
Number 1.
It is submitted that applicant number 1 is ill while in jail and he is aged about 56 years. Applicant number 2 is young man aged about 26 years. Full stop. Considering aforesaid submission, list the matter on Thursday.
21 तारीख 24. Grateful, Mother.
Lordship, the advance copy was served to the Council for Union of India. Thereafter, notices were also issued. Application is for appointment of an arbitrator matter.
So, notice has been issued.
Yes, Lord.
Nobody is appearing.
Nobody is appearing, despite there being an advance copy set upon.
Report. What is the report? Service report.
The report for turn आ गई है. Answered.
Registry is directed to place service report on record. List after 2 weeks.
May be given.
Week commencing.
Number 73.
सॉरी माय लॉर्ड, आई एम फॉर आइटम नंबर 6 माय लॉर्ड. ऐसा लगा कि मुझे आ जाएगा नॉर्मल कोर्स में, पर वो
6 क्या है? नोटिस हो चुके हैं?
नोटिस हो चुका, रिप्लाई
आप किसके लिए अपीयर हो रहे हैं?
हम इसमें एप्लीकेंट.
Who is appearing for other side?
kindly
inform them next week.
1st April or 2nd April में.
Counsel, none appears for respondent. One more opportunity is granted after 2 weeks, week commencing, for final hearing at motion stage.
दिल्ली से आते हैं इसमें.
Counsel appearing for applicant. ये कौन दिल्ली से आता है?
इसमें वो तथागत जी.
ये तो अजय गुप्ता जी तो यहीं के.
मैं अजय गुप्ता हूँ, पर इसमें तथागत जी आते हैं दिल्ली से.
Counsel appearing for applicant made a prayer for giving fixed date in the case as outside counsel is engaged. Place the matter on. 2 हफ्ते के बाद 8 ठीक.
This case is transfer petition, स्वैच्छिक ट्रांसफर पिटीशन का लड़से वाइफ का है. वो बैतूल में पदस्थ हैं, सिवनी में हस्बैंड है.
यस,
सिवनी में उनके हस्बैंड हैं, दोनों टीचर हैं, और वो बैतूल में पदस्थ हैं. वो स्वैच्छिक आवेदन भी उन्होंने दिया था. निज्जर
कहाँ है ट्रांसफर?
सर बैतूल से सिवनी के लिए.
बैतूल से सिवनी
जी.
यस. अब आप क्या चाहते हैं?
सर यही चाहते हैं कि हमारा बैतूल से सिवनी कर दिया जाए, क्योंकि हमारे हस्बैंड भी वहाँ पदस्थ हैं.
आपका रिप्रेजेंटेशन कंसिडर नहीं हुआ है?
जी. यस सर.
स्टेट डिसाइड कर दीजिए. आप petitioner has filed this petition under Article 226 of the Constitution of India, making a prayer for issuing direction to respondent authorities to consider his representation for transfer of petitioner from Bethiam to Sivni. It is submitted that after filing of representation, respondent has not passed any order or communicated a decision on his representation. Government advocate submitted that representation shall be considered in accordance with law, considering aforesaid circumstances without expressing any opinion on merits of the case. Petition is disposed of, directing competent authority, respondent number
3
oblique respondent number 3 to consider and decide representation of petitioner within period of 45 days from receipt of certified copy of order passed today. Petitioner is also at liberty to file a fresh representation along with certified copy within period of 7 days.
7 days.
74. Yes.
My lord, it's a case in which, my lord, the respondents have, my lord, not paid the subsistence allowance to the petitioner during suspension period.
You had made any request?
He has made request, my lord, and representations are on record, my lord.
Decided state? रिजेक्ट तो नहीं हुआ है ना?
नहीं, रिजेक्ट नहीं हुआ है. उसमें सर ऊपर से उन्होंने कुछ इंस्ट्रक्शन भी मांगे हैं, बट
FIR has been registered against petitioner as pleaded by the petitioner.
ठीक है, वो बाद में वो कैंसिल हो गई था. वो that has been.
Then also you are required to pay suspension allowance. Petitioner has filed this petition under Article 226 of the Constitution of India, making a prayer to issue direction to respondent authorities to make payment of suspension allowance to petitioner. It is submitted that suspension allowance is a right of petitioner and necessary for his survival and livelihood. In these circumstances, respondent be directed to make payment. Government advocate submitted that pending representation of petitioner shall be considered in accordance with law. A petition is disposed of, directing respondent and competent authority oblique respondent number.
That is my PO Jila Panchayat. Respondent number 3.
Respondent number 3.
3 and 4, my lord.
3 and 4 to consider and decide representation of petitioner within period of 45 days on receipt of certified copy. Petitioner is also at liberty to file fresh representation along with certified copy before respondent authorities. No on merits.
Number 77.
Yes. No, there is no order as such which is challenged, my lord. I am aggrieved by the fact that the salaries to the petitioners have not been paid for a period of almost 12 months.
12 months?
Yes, my lord. The similar issue cropped up, my lord. This is a matter, my lord, wherein the illegality regarding the absorption was challenged, my lord. The termination orders were stayed and subsequently the petitions have been allowed. Now, the 3 Gram Panchayat salary was not paid. Now, being agreed by that, my lord, various petitions were filed. The coordinate bench has already decided those petitions. The order, my lords, would find at annexure P10 at page number 92.
Yes, disposed of in similar
Yes.
terms.
Now, my lord, the state being agreed by it preferred a writ appeal against that order. Now,
Yes.
that writ appeal was partly allowed only with a direction, if my lords may see the last page of the writ appellate court's order, that it was directed that the salaries be paid to the petitioners who have already discharged their duties, my lord. So in the
So
same
same
term,
order.
yes, my lord, same term they may be directed.
Petitioner has filed this petition under section 226 of the Constitution of India, making a prayer to issue direction / writ to respondents, directing them to pay salary of petitioners. It is submitted that petitioners are not being paid salary for a period of 12 months.
Well, since October
It is
2020.
it is submitted that in similar litigation was disposed of by a coordinate bench, against which state has preferred writ appeal bearing number 116 of 24. Said writ appeal was disposed of by order dated 25 January 24, modifying the order to the extent that that respondents were directed to conduct an inquiry in respect of working of petitioners from January 22 till termination, order dated 15/7/22. If petitioners have actually performed their duties during the intervening period, then the salary for aforesaid period be extended to petitioners. Petitioners were also directed to cooperate in inquiry. Full stop. Government advocate does not have any objection if petition is disposed of in similar terms. Considering the same petition filed by petitioner is disposed of, directing respondents to conduct an inquiry, and if petitioners was found to be working in intervening period, then they shall be paid salary for said period disposed of.
Great.
My lord, application under section 482 of CRPC, my lord, was for Patna or vehicle, my lord. Applicant भी
कौन है आप? Who are you? आप कौन है?
मैं
Accused हैं या
एक्यूज भी है मालूम, परंतु ओनर भी है इसके
गाड़ी के ओनर भी हैं?
हाँ, 3 एक्यूज है इसमें मालूम।
यस।
इसमें ये
कौन सी गाड़ी है आपकी?
मोटरसाइकिल मालूम।
मोटरसाइकिल।
हाँ, इसमें मेरे डॉक्यूमेंट लगाए हैं NH-2 मालूम।
यस।
इसमें ओनरशिप है मालूम इसमें।
ये स्टेट आपकी एप्लीकेशन खारिज हो गई?
खारिज हो गई मालूम।
वेयर इज ऑर्डर?
हाँ, A1 मालूम। मालूम इसमें कोऑर्डिनेट बेंच ने भी ऑर्डर किया है कि इसमें जब तक गिल्टी प्रूफ नहीं होती, जब तक क्वालिफिकेशन की नहीं किया जा सकता है। इंटरिम कस्टडी में
अभी कॉन्फिस्केशन थोड़ी ना, आपको तो सुपुर्दगी नामा पे चाहिए।
हाँ,
ना
नहीं तो उन्होंने ये माना है कि 47 सबसेक्शन 3 में कॉन्फिस्केशन की प्रोसीडिंग पेंडिंग है, इस कारण मजिस्ट्रेट नहीं दे सकता इसमें।
ये किसने माना है?
ऐसे काइंडली से पैरा मालूम,
वो तो एक्ट में लिखा हुआ है कि दे सकता है।
9
कहाँ है?
पेज नंबर 9 में मालूम।
यस।
पैरा 6 मामला 34/2 मध्य प्रदेश आबकारी अधिनियम अपराध का है। विचारण न्यायालय के अभिलेख से संलग्न कार्यालय, कलेक्टर, जिला दंडाधिकारी, सूचना पत्र शो एंड सो।
ये तो बार है, ट्रायल कोर्ट। आप वहां जाइए ना, गो बिफोर कलेक्टर।
डायरेक्शन का मालूम इसमें
डायरेक्शन की क्या जरूरत है?
इसमें
यहाँ पे बाहर है तो आप वहां जाइए। यहाँ पे इनके पास इंफॉर्मेशन आ गई है कॉन्फिस्केशन।
हाँ, कॉन्फिस्केशन की इंफॉर्मेशन आ गई इनके पास। प्रोसीडिंग अभी पेंडिंग है मालूम।
Petitioner has filed this petition under section 482 of Code of Criminal Procedure for release of vehicle on supurdgi nama. It is submitted that magistrate by its order dated so and so refused to interfere in his application for release of vehicle on supurdgi nama as intimation about confiscation proceedings, about institution of confiscation proceeding was given to magistrate. Full stop. It is submitted that court may exercise its inherent power for release of vehicle on Supurdgi Nama. Full stop. Third, government advocate opposed the application and submitted that applicant ought to have approached collector, district magistrate for releasing of vehicle on Supurdgi Nama. Heard the counsel for the parties. Magistrate under section 47 of MP Excise Act 1915 has power to release the vehicle on Supurdgi Nama. In view of same, petitioner is directed to approach district magistrate by filing appropriate application for release of vehicle on Supurdgi Nama. Petition is disposed of.
Problem.
For which time I'll reply. Please watch.
Just a minute. Yes.
For which time to reply.
Yeah, what is the matter?
Matter is that whether by this petition alleging the order of SDO whereby even dated 11/2023.
Appeal. None appears. One more opportunity is granted to petitioner to argue the case. It is made clear that if none appears for petitioner on next date of hearing, then case may be dismissed for want of prosecution. After 4 weeks, we commencing.
Arbitration appeal. Application under section 20 rule 4.
First time listed.
This is listed second, third time. Notice were already issued, but after someone the respondent not marked their presence and was died. Major retired SR Godra, and after the death, there is application for substitution of LRs taken on record. नोटिस जारी हुए थे पिछली तारीख को, सर्विस रिपोर्ट नहीं आई है अभी इसमें.
रिपोर्ट है क्या? सब्स्टिट्यूशन ऑफ एलआरसी में तो पेंडिंग बता रहा है एप्लीकेशन.
नहीं, एप्लीकेशन डिसाइड हो गई, मतलब पेंडिंग है. नोटिस किए थे एप्लीकेशन, नोटिस हुए हैं. Because their application for setting aside amendment also in the
when they filed their application,
it is filed on 8th of December.
ये तो इनको सर्विस हो गई है. राजेश गोदरा ने
8/12/2023 को फाइल की.
अनसर्व्ड है, इसने लेने से मना कर दिया.
तो सर पहले भी तो सर्विस के बाद भी नहीं आए हैं. ये जो नंबर 1 है ये सर्विस के बाद भी उपस्थित नहीं हो रहे हैं.
Respondent is proceeded ex parte. Trial registry is directed to call for the records of arbitration case and reference case from district court. List after 4 weeks, week commencing. ये records are already there. आप कब बहस करेंगे?
After 4 weeks कर लेते हैं. First week in the month of April.
List after 4 weeks ही कर दो for hearing of the case. एक मैडम दोनों सर हो गए, इसमें दो हैं एप्लीकेंट्स।
मैडम सर्विस के बाद भी नहीं आया ये तो, ये सन 2015 ही में सर्विस, 2017 में ही इसको सर्विस हो गई थी नोटिस
दोनों को।
पर
ये
नहीं,
वन की तो डेथ हो
दोनों
गई।
को, हाँ, दोनों को सर्विस हो गई थी। ये वन की डेथ होने के, ये नंबर दूसरा जो है इसका लड़का है, नंबर 1 का।
नंबर 2 इज प्रोसीडेड एक्स।
अभी हमने इसको पार्टी
इनको सर्विस हो गई थी ना, दो
सर्विस हो गई।
यस लिख देना, नन अपीयर्ड आफ्टर सर्विस, इसको रिकॉर्ड में चेक कर लेना सर्विस हुई। यस
If it may please your lordship, there is this application.
This
for
is item number
3.
Yes.
There is an application for amendment, your lordship.
Notices has been issued.
No. Notices has not been issued. Amendment में there is a change
IA
in address.
so and so is allowed. Amendment be incorporated within period of 7 days. List thereafter for admission.
4 is similar, my lords.
Yes.
Item number 4
Same.
is also similar.
3 और 4 दोनों में कर दें। Registry is also directed to call for records after 4 weeks कर। Oh, ये तो arbitration केस है, सिर्फ नोटिस है ना, PF 7 days, return 4 weeks। हाँ, सिर्फ नोटिस।
My lord, I am humbling bring pass over, my lord. Senior will argue this matter.
Pass over it may not reach.
Audit. So, case of
क्या है?
2017, my lord, recovery matter, my lord, punishment मिली, punishment. T7, my lord.
After 4 weeks be commencing.
My lord, I pray it may be any fixed date may be granted, my lord.
Be commencing date डाल दे। Yes.
Syllabus 61.
Nice.
None appears adjourned. Application IA. Yes, state any objection? Amendment है, आपका नोटिस भी नहीं हुआ अभी तो। None appears after 4 weeks.
65.
Yes.
My lord, this is the petition. I have moved in IA for modification. I for the respondents.
None for appealant. After 4 weeks.
Number 84. Gupta.
None appears adjourned 4 weeks.
Number 86. One thing.
None appears adjourned. Yes. बाहर आ रहा है ना, ठीक है।
Number 86.
डिस्प्ले बोर्ड पे आ रहा है ना। None appears adjourned 4 weeks.
Number 87.
Yes.
No, may kindly see the last order. Respondent, and this is a contempt matter.
Yes.
The respondents have submitted that they had issued an order, however, no compliance report has been filed. And there was a specific direction to comply in the manner where the consequential benefits are also given to the petitioner. The date of superannuation was extended by the orders of the Honorable Court.
Superannuation extended.
G. The age was extended from 62 to 65 in consideration of the rules.
Then what happened? You completed your service.
We completed our service. Our wages were due, for which we had submitted our representation, and also the consequential benefits were to be given. None of
For
that
3
thing has
years
been
you were
complied
not
with.
paid. 3 साल में आपको कुछ नहीं दिया है.
No, my lord.
After joining, they have not paid you.
No, my lords. In fact,
Yes, state.
we had also written for the.
What is your reply? Despite orders of court, you are not paying him.
And now I stand retired. my lords.
You have also been served. क्या कहना है आपको? Who is appearing? इनको पर्सनली बुला लेते हैं. Nobody is interested. इनका काउंसिल भी इंटरेस्टेड नहीं है डिफेंस में. जवाब भी अभी तक कुछ पेश नहीं किया.
They, for the disclosure, my lords, on the last date of hearing, they had given a copy of an order. However, this is not a proper order. We had made submission ki, first of all, this has not been brought on record. Plus, this is not according to the orders of the.
None appears for respondent. Last opportunity is granted to respondents to comply with the order passed by this court and file its reply. Full stop. If reply is not filed, then court may last opportunity after 2 weeks we commence. Inform him, whoever is appearing.
Small prayer, my lords.
Yes.
In case they go with this order that they were referring to, they go with that order and produce a compliance report. My lords had very well verified in the last order sheet as to what has been made and what needs to be made. That the previous order was like an empty formality. If there can be a kind reference to the last order of the Honorable Court, then only they'll make payments of the consequential benefits, or at least come out with an order that says that the payment shall be made.
So time was granted to seek instruction.
My lords, twice they took time before passing of this order, then they showed this order that this will be brought in the compliance.
None appears for respondent. Last opportunity is given to respondent to argue the case. It is made clear that if respondent, counsel for respondent does not appear on next date of hearing, then personal presence of respondent will be ordered, shall be ordered by this court after 2 weeks week commencing.
Obliged, my lords.
None appears. 4 weeks. क्या है? What is the matter?
सर इसमें पेंशन पेमेंट का था और इसमें हमको पिछली बार डायरेक्शन थे कि इंस्ट्रक्शन देने हैं. इसमें पेंशन ऑफिसर को हमने लिख दिया है. ये 15 दिन में हम पेंशन मिल जाएगी.
Government advocate appearing for
पेमेंट इनकी सर्विस बुक मिस हो गई थी, वो उसके कारण उनका पेंशन केस तैयार नहीं हो रहा था. तो अभी हमने पूरा सर्विस बुक सर्च करके सर्विस बुक का पूरा वेतन नियमित बना के वहाँ भेज दिया है. पेंशन ऑफिसर को ऑर्डर
government advocate appearing for state submitted that respondents are making efforts to get the pension case of petitioner cleared. He is hopeful that petitioner may be paid pension within short period of time. Considering aforesaid circumstance, list the matter after 2 weeks week commencing. None for petitioner. None appears. 4 weeks.
Take the 4 increments of the petitioner.
I prefer 4 weeks time वाला to file it.
4 इंक्रीमेंट पेंशन में फर्क पड़ा, जबकि हमारे पास कोई ऑफेंस ही नहीं सीधी बात.
Let them file their reply. Government advocate prays for 4 weeks time to file reply. Prayer is allowed. List matter after 4 weeks week commencing.
My lord, 67
apologies, my lord. I'm requesting for matter number 83, my lord. Due to some difficulties, I couldn't mention in the morning. If my lord may deem fit.
83,
my lord.
देखते हैं लास्ट में आफ्टर डायरेक्शन मैटर्स देखते हैं.
On the last date, Lordship, this honorable court has directed, explain Lordship, that by 304B and 498A,
yes,
not be added in this challan, my lord.
Yes.
Investigation officer is also present before your Lordship.
Yes.
इसमें
पूछिए उनसे क्यों उन्होंने 304 भी नहीं बनाया है, जबकि
इनका ये कहना है कि ये जो मर्ग रजिस्टर्ड हुआ लॉर्डशिप, मर्ग रजिस्टर्ड होता है 21/10/2023 में.
21/10/23.
हाँ.
यस.
21/10/23 में जो मर्ग इंटीमेशन जो है वो डिसीज्ड का हस्बैंड देता है लॉर्डशिप. हु इज द एक्यूज्ड इन दिस केस आल्सो.
यस.
उस मर्ग रिपोर्ट में आई रीड लॉर्डशिप.
यस.
मैं सो एंड सो अपने चाचा उमा शंकर के साथ थाना आकर
304B was not.
मतलब इसी में जो कंफ्यूजन हुआ लॉर्डशिप, जुबानी रिपोर्ट किया कि मेरी पहली शादी सो एंड सो इनके साथ हुई थी. शादी के 3 साल बाद मेरी पत्नी का बीमारी कारण मृत्यु हो गई थी. तो मैं वर्ष 2013 में इनके हस्बैंड का कहना है कि वर्ष 2013 में ग्राम किरगुआ में उमा भारती जोगी, हु इज द डिसीज्ड माय लॉर्ड, को विदा कराकर लाया था. मेरी पत्नी की उम्र 36 साल है. मेरी पत्नी के पहले एक बच्ची थी जो अर्लियर हस्बैंड की, एवं मेरे यहाँ आने के बाद उसके 2 बच्चे हुए. बड़े बच्चे का नाम सो एंड सो 3 साल, दूसरे बच्चे का नाम सो एंड सो 1.5 साल है. तो इनका कहना ये था लॉर्डशिप कि हम 2013 में विदा करा कर लाए थे. घटना जो घटी वो 2023 में घटी, तो वो 10 साल का हुआ लॉर्डशिप. इससे वो 28 तारीख को.
पेरेंट्स क्या कह रहे हैं?
पेरेंट्स का जो बयान होता है लॉर्डशिप वो 1.5 महीने बाद होता है.
हाँ, क्या कहते हैं वो?
तो पेरेंट्स तो 28/11/2023 में पेरेंट्स का बयान होता है. तो पेरेंट्स कहते हैं कि हमने अपनी बेटी की शादी 2019 में की थी.
Then it is within 4 years.
Within 4 years. लेकिन there is no evidence regarding the marriage. तो 19 में शादी हुई तो कोई ओरली उनसे मांगा गया कि आप दस्तावेज लाइए.
हस्बैंड ने क्या एविडेंस दिया?
हस्बैंड का तो मर्ग रिपोर्ट है लॉर्डशिप.
तो उसका भी तो ओरल है. एक्यूज के स्टेटमेंट आप बिलीव करेंगे?
नहीं, बिलीव कंफ्यूजन बता रहे हैं लॉर्डशिप. कंफ्यूजन जो हुआ है,
व्हाटएवर मे बी कंफ्यूजन, इनका भी ओरल है, हस्बैंड का भी ओरल है. आप हस्बैड एक्यूज का ओरल मान लेंगे?
नहीं मान नहीं रहे लॉर्डशिप.
तो फिर आपने बनाया नहीं 304 भी?
हाँ, बस वो लॉर्डशिप इन्वेस्टिगेशन ऑफिसर
304 भी बनाइए, क्यों नहीं बना रहे हैं? क्या होगी?
टूटी बस गलती.
304B का एडिशनल जो भी है चार्जेस फाइल करेंगे.
चार्जशीट फाइल होने के बाद कोर्ट से परमिशन लेते हैं.
हाँ, परमिशन लेके करिए. यस.
मेरा सबमिशन इतना है, जो आईओ की रिपोर्ट है उसमें सिर्फ जनरल एलिगेशन सबके ऊपर लगाए हैं उन्होंने. और मैं लॉर्डशिप एक हम जस्ट एग्जैक्ट A3 पेज नंबर 70 is the bail application of हरिराम जो भी है.
आप तो हस्बैंड है ना क्या?
नो मैं लॉर्डशिप, मैं हम सास है मैं लॉर्डशिप.
इनका कोई स्पेसिफिक एलिगेशन है?
तो सबके ऊपर एक ही जैसा एलिगेशन इन्हें लगा है.
ये है लॉर्डशिप कि हमने मेरे दामाद नीरज, सास भानाबाई, ससुर हरिराम, ननद सुवन और देवर इसको लेकर आए दिन मारपीट. जनरल एलिगेशन इसी आधार पर अर्लियर लोगों की बेल भी हुई.
यस. क्या कहना आप?
काफी लोग सभी लोग मिलके जो है मानसिक शारीरिक रूप से परेशान किए दहेज के लिए, और इनको अग्रिम जमानत पे घोर आपत्ति है सर. उनको नहीं देना चाहिए.
तो क्यों नहीं देना चाहिए? आपने तो कुछ बताया ही नहीं है. कब मारपीट करी, क्या किया? कुछ नहीं है. सब जनरल एलिगेशन है, सब मांगते थे.
21/10/2023 की है.
यस.
शादी 2019 में हुई. फर्स्ट बेल एप्लीकेशन.
Tell them to make, tell the investigating officer to take action, proper action. तो इनके अगेंस्ट तो कुछ भी नहीं है, जनरल एलिगेशन है बस. और ये भी डाउटफुल है कि शादी कब हुई, आप कह रहे हैं 19 में हुई है, ये कह रहे हैं 13 में हुई है।
FIR इस चालान में भी, कथन में भी 2019 का मेंशन है लॉर्डशिप।
बट दिस इज रियली वेरी स्ट्रेंज कि आप एक्यूज का स्टेटमेंट मान के आपने 304 भी नहीं बनाया। मदर फादर बोल रहे हैं 19 में शादी हुई है, उसको आप एकदम वेटेज ही नहीं दे रहे।
नहीं केवल जो कंफ्यूजन हुआ वो मैं बता रहा था। मतलब आयोग का कहना ये है कि इस हिसाब से बाकी
यस, और कुछ स्पेसिफिक एलिगेशन है इनके अगेंस्ट में?
बाकी इन संपत्ति का ब्यौरा मांगा था, चल संपत्ति का।
क्यों, ये एब्सकॉन्डिंग है क्या?
एब्सकॉन्डिंग।
तो आपको तो एंटिसिपेटरी बिल नहीं देंगे, कब से एब्सकॉन्डिंग है?
21/10/2023 28/10 28/10 में हुई और फरारी पंचनामा भी इनके पूरे लगे।
आप तो एब्सकॉन्डिंग है।
डॉक्टर बस एक सबमिशन है 10 मेरा, उसको आप देख लें, उसके बाद पेज नंबर 18 में डॉक्टर एनेक्सर
18,
हाँ एनेक्सर A3।
यस
डॉक्टर इसमें जो ऑर्डर पिछली जो एंटिसिपेटरी हुई है उसमें पैराग्राफ नंबर 5 में स्पेसिफिक लिखा है एप्लीकेंट नंबर सन नंबर 1।
ये किसकी हुई है?
ये मिलॉर्डशिप इनके ससुर की हुई है और इनके देवर
की हुई।
इसमें लिखा है मिलॉर्डशिप एप्लीकेंट नंबर 1 सन हैज मैरिड टू डिसीज्ड उमा भारती जोगी एट एडवांस स्टेज ऑफ लाइफ व्हेन ही वाज 37 years of age. Uma Bharati Jogi had done third marriage with son of applicant number 1, and from earlier wedlock she was having one daughter. Points toward the liberal mentality of the family.
Applicant has filed second application under section, ये आपकी second है?
Yes, my lord.
ये इसमें तो हो गई, कंसीडर हो गया आपको, देयर इज नो चेंज सर्कमस्टेंस।
मेरा लॉर्डशिप इसके बाद ये इसके बाद हुई है मेरा लॉर्डशिप।
फर्स्ट एप्लीकेशन फाइल्ड बाय एप्लीकेंट वाज डिसमिस्ड, देयर इज नो चेंज इन सर्कमस्टेंस, रिपीट एप्लीकेशन इज आल्सो डिसमिस्ड।
But this is a third bail application under section 439.
Yes.
Earlier was dismissed with liberty to file after the.
You were driver?
I'm the driver of the vehicle.
Yes.
But, both the seizure witnesses have turned hostile before the trial court, my lord.
कितना मिला? How much is seizure?
275 kg, my lord. I'm merely the driver, my lord. I was asked, I hired by the
compliance 52.
एग्जीक्यूटिव मजिस्ट्रेट के सामने
कब सैम्पलिंग करी एग्जीक्यूटिव मजिस्ट्रेट ने?
2021 11/6/21 की रसीद है।
मतलब एफएसएल की सैम्पलिंग यही वाली भेजी है मजिस्ट्रेट वाले।
व्हाट्सएप इसमें डेट लिखी हुई है 11/7/21।
हाँ 11/6/21 को एफएसएल की रसीद है।
वो एफएसएल और समरस पंचनामा 10/6 को हुआ था इन द अब्सेंस ऑफ एग्जेक्टिव मजिस्ट्रेट।
सारी कार्रवाई सारे पेजेस लगे, सारी कार्रवाई
ये आफ्टर 1 month किया गया है। इस पे एग्जैक्ट डेट लिखी हुई है ऑर्डर शीट पेज नंबर
11/7 तो लिखा हुआ है इसमें।
हाँ 11/7 लॉर्ड, नॉट 11/4, 11/6। हर जगह 11/7 है लॉर्ड। लेबोरेटरी में जो सैंपल रिसीव हुआ है वो 10/6 को हो गया, 11/6 को।
10/6 को हो गया।
हाँ
क्वांटिटी इज यू
नॉट सिर्फ फर्स्ट टाइम ऑफेंडर, और हम जो उसमें हेल्पर थे कोई आइडिया नहीं था कि वहां पे क्या हो रहा है। अलर्टशिप इसमें 20 बार जो है सम्मान इशू हो चुके हैं विटनेसेस को, लेकिन फिर भी नहीं आ रहे।
कब से आप लोग जेल में?
मतलब 9 June 2021. Don't have criminal records, my lord.
There is a huge violation of his standing order.
State has done sampling. बाकी तो आप ट्रायल में प्रूव करिए.
लॉर्डशिप इस पे जो नहीं, बट वो सैंपल भेजा नहीं गया ना लॉर्डशिप.
यस,
वो सैंपल भेजा ही नहीं गया है. सैंपलिंग हुई है 11/7 में. ये लेबोरेटरी की रिसीट है. जो एग्जीक्यूटिव मजिस्ट्रेट ने सैंपलिंग की है वो 11/7. ये ऑर्डर से दैट इज रॉन्ग. ये तो हमारा सबमिशन है, दैट इज रॉन्ग.
ग्यारह सात को तो आपने सील तोड़ी है.
लॉर्डशिप इसमें और भी
11/7 को आपने जो आईओ ने इसको सील पैक किया था वो खोला है आपने, और फिर आपने सैम्पलिंग करी 11/7 को. एफएसएल आप 11/6 बता रहे हैं.
11/6 रिसीट है. इज एडमिटिंग आल्सो.
दस 6 में तो पकड़ा उन्होंने, उसी दिन सैम्पलिंग करके भेज दिया एफएसएल. वो तो आईओ ने भेजा है ना, तहसीलदार ने 52.
इसमें और कॉन्ट्रडिक्शन है लॉर्डशिप. इन्होंने जो एफआईआर में कहा है 275 बैग इज हैविंग अ 1.050 क्वांटिटी केजी, उसके हिसाब से 288 किलो होता है जो एफआईआर में लिखा गया है, और जो सीजर मेमो है उसमें 250 किलो लिखा हुआ है.
Applicant says file third application under section 439 of Code of Criminal.
माइन इज फर्स्ट लॉर्डशिप.
First और एक में
21
third कर देना. Counsel appearing for applicant submitted that applicants are driver and helper of the vehicle. It is submitted that they are innocent, falsely been implicated. There is non-compliance of provision under section 52A, full stop. Magistrate has done sampling on 11/7/21. IO has seized the narcotic substances, that is ganja, on 10/6/21, and on the same date, homogeneous mixture was made and same was sent for FSL examination. It was received in FSL. कब रिसीव हुआ है?
11/6
on 11/6/21.
Yes, Lord.
On 11/6/21, full stop. It is submitted that executive magistrate ought to have done sampling from each packet, and then he ought to have sent it for FSL examination. Full stop. Mixture was made homogeneous, therefore there is no primary evidence as such. After destroy हो गया है, गांजा destroy कर दिया है.
Yes, Lordship, क्योंकि 2000
after destruction of ganja
में डिस्ट्रक्शन का ऑर्डर है 11/7 का.
On 29/9/21. In these circumstances, applicant be released on bail. Government advocate opposed the application and submitted that magistrate has acted in accordance with section 52A and has done sampling of ganja. Full stop. No error is found. There is no procedural error which is fatal to the prosecution case. Heard the counsel for the parties. There is non-compliance of section 52 capital A of NDPS Act 1985, which is mandatory in nature. Considering aforesaid, application is allowed. Applicants be released on bail. कितने case?
My lord, I don't have any.
No, Lordship, there is no.
Applicants will mark their presence before local police station twice every month. If they are found involved in any other offense in future, then trial court shall get the applicant arrested, and on receiving information, applicant shall be arrested and sent to jail. Bail order passed by this court shall automatically stand cancelled. Applicant will attend the trial on all dates when required, and they will not seek unnecessary adjournments. Yes, next.
Oh, like.
रिप्रेजेंटेशन डिसाइड करवाने के लिए
क्या है 67?
वो में निलंबित किया गया था, निलंबन के बाद बहाल किया गया, और हम निलंबन अवधि का वेतन और वो जो इंक्वायरी 2019 से चल रही है उसको हम चाह रहे हैं कि कंप्लीट कर दें। 2019 से कंटिन्यू अभी भी चल रही है, केवल इतना चाहते हैं कि वो
कंक्लूड कर दें डिपार्टमेंटल इंक्वायरी। रिप्रेजेंटेशन आपका पेंडिंग है?
यस माय लॉर्ड। एनेक्जर P4 पेज नंबर 13
है ना? Petitioner has filed this petition under Article 226 of the Constitution of India, making a prayer to direct respondent authorities to consider and decide his representation in respect of payment of allowances during period of his suspension, and also to conclude departmental inquiry in time-bound manner. It is submitted that departmental inquiry was initiated against petitioner in year 2019 and is continuing since then. Petitioner has been reinstated. Suspension of petitioner has been revoked. Revoke हो गया है ना?
Yes, ma'am.
Government advocate appearing for state submitting that representation of petitioner shall be decided by respondent authorities concerning his dues, and further efforts will be made to conclude inquiry in time-bound manner. Considering aforesaid circumstance, writ petition filed by petitioner is disposed of, directing respondent authorities to consider the representation of petitioner for payment of allowances and arrears, if any, to petitioner during the period of suspension and joining and revocation of suspension. Further, respondents are directed to conclude departmental inquiry within period of 6 months from receipt of certified copy of order passed to them. No opinion is expressed on merits.
Respondent number 4 के यहाँ pending है.
Respondent number 4 is directed to your District Education Officer, Satna.
Obliged.
Yes. ये डायरेक्शन की बात देखिए.
But this is to be finally heard.
Who is appearing for respondent?
Not nobody is appearing. They have proceeded ex parte.
This is what?
Not the arbitration appeal, not under the old act.
Yes.
1940 Act.
The records are.
एक प्रिंट आउट दे दोगे? Print out, scan copy. No, I'll just supply a lot of the scan copy. I've got scanned everything, but one document was left out. जब दोनों तरफ कर दो जल्दी फटाफट. It would make your lots of work very easy.
Yes.
Not, I'll make the entire case very short now, because it is directly, only one point is directly covered by the judgment of the Supreme Court.
Yes.
What had happened, my lord? On 7/3/1983, an application under Section 20 of the 1940 Act was filed before the district judge Lord for appointment of an arbitrator.
Yes.
But the dates are mentioned in that document.
Yes.
Then, my lord, on 4/8/98,
yes,
the arbitrator was appointed. The respondent number 2 was appointed.
Yes.
Now, my lord, when the application was made, the old act was in force, And when the arbitrator was appointed in the year 1998, by that time 1996 Act had come into force. So, my lord, the issue is not whether the proceedings would continue under the old Act or under the new Act. Not from the award, Lord, it is not gathered as to what was the intention of the parties, whether to continue under the old Act or under the new Act. But not under the old Act, the arbitrator was required to submit an award before the district judge for making it a rule of the court under Section 14 of 1940 Act.
Yes.
He submitted a covering letter that arbitration under Arbitration Act 1940. He submitted a letter along with the award and the related documents before the court. The court not issued us the notice to submit our objections. We submitted our objections, not, and those objections have been decided by the court, not against which this appeal has arisen. Now we have filed an appeal under Section 39 of the old Act, Lord. 39, 1 and 7 of the old Act. Now, Lord, the other events which are necessary for taking into consideration is not that I filed an application for removal of an arbitrator on 1/5/1999. This application was dismissed.
Yes.
On 28/10/1999, I filed a revision petition, Lord, that is 224 of 2000, in which, Lord, this court directed that within 4 months, I am supplying the certified copy of the order. This is referred to in the impugned order also, Lord.
Yes.
That the matter be decided within 4 months. Challenge is to the order dated 28/10/1999 passed by the 7th Additional District Judge Bhopal in RCS number so and so, wherein he has refused to accept the prayer of removal of the arbitrator. The respond number 2 herein. It is submitted by Shri Hundigal and Counsel that the arbitrator is guilty of laches as he has not proceeded with the arbitration. Considering the submissions raised by the learned counsel for the petitioner, while declining to interfere with the impugned order, I am inclined to direct that the arbitrator shall take expeditious steps to dispose of the proceeding pending before him within a period of 4 months from the date of receipt of the order passed today. So, similar, the court had fixed the period of 4 months from 4 months period for delivery of the award. Now, Lord, he was informed about this award by a registered letter, Lord, and just producing, Lord, the original copy.
Yes.
By the counsel, Lord, along with the postal receipt. He was informed.
Yes.
Now, Lord, Lord, your Lordship may take this. इसमें 21(3) लिख गया serial number 7 में, it should be 31(3), my lord. One correction.
Yes.
Then what, he did not pass an award within 4 months. So, my lord, there's a direct judgment of the Supreme Court that arbitrator suo motu cannot enlarge the time. He becomes functus officio immediately upon the expiry of the time fixed by the court for delivery of the award. Now, my lord, what had happened? I filed another application on 7/4/2000 for removal of the arbitrator. Now, this application was also dismissed by order dated 5/11/2000, Lord. The application was dismissed by direction to conclude the proceedings within 15 days and directed to appear on 13/11/2000, Lord. Now, he did not pass an award within 15 days. Now, Lord, I filed another application, Lord. 9/2/2001, respondent number 2 did not conclude the proceedings within 15 days. Therefore, applicant again moved and filed an application for removal of the arbitrator. Then, Lord, on 22/3/2001, he passed on award. So, Lord, if your Lordship would see serial number 9, 5/11/2000, the district court did not have the power to enlarge the time or extend the time which was fixed by the High Court, my lord. Because in the High Court had fixed the period of 4 months. So only the High Court could have extended the time. It was for the arbitrator or the parties to approach the High Court for the extension of time, my lord.
Yes.
Now, my lord, in this background, this amounts to a misconduct on the part of an arbitrator as under Section 1333 of the old Act. But I'll refer to the provisions also.
Yes.
Now, the direct judgment of this court, my lord, of the Supreme Court, my lord,
Yes.
2010 2SCC, my lord.
Yes.
The similar situation had arisen here also.
Yes.
But if your lordship would see, I will start from paragraph 4.
Yes.
Meanwhile, the appointing authority had appointed 3 arbitrators due to the above mentioned reason, and the arbitration process had come to a standstill due to the inaction of the respondent and its failure to participate. Thereafter, on 20th May 2004, the respondent filed an application before the Calcutta High Court seeking removal of the then incumbent arbitrator, and the arbitral proceedings were stayed by the court. On 29 2004, the High Court directed the chairman and managing director of the appellant company to appoint a new arbitrator in terms of the arbitration clause within a period of 4 weeks from the date of communication of its order. The High Court further directed the arbitrators who appointed to conclude the arbitration proceedings within a period of 6 months from the date of his appointment. Pursuant to the order of the High Court, the chairman and managing director of the appellant company appointed Shri A.K. Gupta, Deputy General Manager of the appellant, as the sole arbitrator. The said arbitrator finally concluded the proceedings after hearing on 18/6/2005. He concluded, but the award was not passed. It is an admitted position that the time to conclude the arbitration proceeding in terms of the order of the High Court before Shri A.K. Gupta, who was appointed as the sole arbitrator by the chairman and managing director of the company, had by then already expired. However, both the parties extended the time to conclude the arbitration proceeding and to pass an award accordingly. The time was enlarged for conclusion of the arbitration to 30/9/2005. It is also an admitted position that the time limit so fixed that is arbitration must be concluded and the award must be passed within 30/9/2005 could not be adhered to by the arbitrator and failed to publish the award within this period. About 3 months after the expiry of the period of concluding the proceeding and passing of the award, it was respondent who moved an application before the High Court for a declaration that the mandate of the arbitrator had already stood terminated. We may keep it on record that the appellant had not filed any application for enlargement of time for the conclusion of the arbitral proceedings or to pass the award after the expiry of the period. Here also, the same position is a prevailing law. Nobody made an application for the enlargement of the time or for extension of the time, either by the arbitrator or any of the parties. But rather, we have been making an application for his removal because he did not adhere to the strict time limit fixed by the High Court. On 22/12/2005, the Honorable High Court, by the interim order, restrained the arbitrator from making an award and at the same time had refused to accept the award produced by the arbitrator before it, which was well beyond the period fixed by the High Court. On 23/3/2006, the High Court, by its impugned order, terminated the mandate of the arbitrator on the ground of delay in making the award. The appellant then challenged the above mentioned order of the Calcutta High Court before this court by SLP number so and so. At the same time, the High Court, by the impugned order so and so, passed an AP number so and so, appointed Mr. Justice Chitosho Mukherjee, as his lordship then was, as the sole arbitrator to adjudicate the dispute between the parties. The appellant, feeling aggrieved by this order, as well has filed a special petition which came to be registered as SLP number so and so, which after hearing the learned counsel for the parties and on grant of leave was heard in presence of the learned counsel for the parties. We have heard the learned counsel appealing on behalf of the parties and examined the impugned orders of the High Court and also other material on record in depth and detail. As noticed here and earlier, the respondent had made an application before the Calcutta High Court under Section 14 of the Arbitration Conciliation 1996 for a declaration that the mandate of the arbitrator Shri A.K. Gupta had already stood terminated. As had already been mentioned above, the appointing authority had appointed 3 arbitrators prior to appointment of Shri Gupta, who were unable to conduct the arbitral proceedings for the reasons, for some reason or the other. It may be kept on record that the respondent had filed an application before the High Court for a declaration that the appointment of arbitrator, namely Shri so and so, who was appointed as the sole arbitrator prior to the appointment of Shri A.K. Gupta, had stood terminated by an order dated so and so, by which the High Court had terminated the appointment and ordered appointing authority of the appellant to appoint a new arbitrator who will conclude the proceeding and pass an award within 6 months from the date of his appointment. Subsequent to this order of the High Court, the appellant appointed Shri A.K. Gupta as the new arbitrator who was to complete his proceedings by 27/3/2005, that is 6 months from the date of his appointment. It is pertinent to mention that the appellant did not file any appeal against the above mentioned order of the High Court. Therefore, it may be taken that the appellant had accepted the aforesaid order of the High Court and thereby accepted its decision to fix the time of the arbitration proceeding to be mandatorily concluded within 6 months from the date of appointment of the arbitrator. The order, thus having assumed finality, a time limit was imposed for the conclusion of the arbitration proceedings. Thus, the appellant is stopped from raising any objection against the imposition of the time limit, as had been done by the court in this respect. From the records before us, we have noticed that in spite of the conducting number of proceedings, the arbitrator was unable to conclude the proceedings within the time fixed by the High Court. The arbitration clause in the contract enables the arbitrator to extend the time for making and publishing the award by mutual consent of the parties. From a perusal of the documents before us, we noticed that the parties mutually agreed to extend the time till 31/8/2005 for making and publishing the award, which was further extended by the parties till 30/9/2005 on account of the arbitrator having failed to conclude the proceedings within the previous date fixed by the parties. But the arbitrator having failed to do so by 30/9/2005, the respondent moved the High Court to terminate the mandate of the arbitrator, as he had failed to conclude the proceedings within the time limit fixed by the parties. The High Court accordingly terminated the mandate of the arbitrator on account of his failure to publish the award within the time fixed by the parties. We are of the opinion that the High Court was perfectly justified in doing so on an application filed by the respondent before it. Quite interestingly, it has come to our notice that the arbitrator in question had appeared before the High Court and submitted that the award was ready, but the same could not be published on account of the interim order passed by the same, restraining him from publishing it. There was, however, no order of the court restraining the arbitrator from publishing the award till almost 3 months after the expiry of the time fixed by the mutual consent of the parties to make and publish the award prior to the interim order passed by the High Court. The perusal of the arbitration agreement quite clearly reveals that the arbitrator has the power to enlarge the time to make and publish the award by mutual consent of the parties. Therefore, it is obvious that the arbitrator has no power to further extend the time beyond that which is fixed without the consent of both the parties to the dispute. It is an admitted position that the respondent did not give any consent for extension of time of the arbitrator Thus, given the situation, the arbitrator had no power to further enlarge the time to make and publish the award, and therefore his mandate had automatically terminated after the expiry of the time fixed by the parties to conclude the proceedings. So, my lord, this is the position. Here, my lord, the parties did not extend. The court fixed for 4 months, my lord. That time limit was not adhered to. Then the dispute granted further time. I read the relevant portion of the judgment.
That is the only point.
My lord, there are other points, my lord. If I succeed on this point alone, my lord, then I need not go into the other point. 83 का agreement था, 40 साल तो वैसे ही हो गए, parties का भी पता नहीं आज की तारीख में क्या मालूम settle हो गया नहीं हो गया, my lord, we don't know. Nobody is in contact, my lord.
Yes.
So, my lord,
want to read?
Paragraph 18.
Yes.
Paragraph 18, lord. Only 3-4 paragraphs, lord.
Yes.
अगली आपत्ति यह उठाई गई है कि न्यायालय के द्वारा अवार्ड पारित करने के में जो 4 माह व पश्चात 15 दिन की अवधि, 4 माह फिर एक बार डिस्ट्रिक्ट कोर्ट ने 15 लॉर्ड, आई विल सप्लाई द कॉपी ऑफ द ऑर्डर टू योर लॉर्डशिप लॉर्ड. आई हैव गॉट ऑफ दैट इज 5/11/2000 एक अलग ऑर्डर से हमने लग रखा, मैं आपको दे देता हूँ, जिसमें कि 15 दिन का टाइम कोर्ट ने ऑर्डर दिया था. आई विल सप्लाई दैट ऑर्डर ऑल्सो. निर्धारित की गई थी उस अवधि में अवार्ड पारित नहीं किया गया है. जैसा कि आर्बिट्रेशन कार्रवाई के अवलोकन से प्रतीत होता है, न्यायालय के द्वारा दिनांक 13/11/2000 ये कोर्ट हैज हेल्ड, ये ऐसा प्रतीत होता है, हाँ 4 माह में नहीं किया गया. जैसा कि आर्बिट्रेशन कार्रवाई के अवलोकन से प्रतीत होता है कि न्यायालय के द्वारा 13/11/2000 की तिथि उभय पक्ष के उपस्थित होकर अपने अपने पक्ष के से संबंधित दस्तावेज प्रस्तुत कर आर्बिट्रेशन कार्रवाई भाग लेने के निर्देश दिए गए थे. इसके बावजूद भी स्वयं आवेदक की ओर से दस्तावेज प्रस्तुत करने के समय लिया गया. ऐसी स्थिति 3/11/2000 के आदेशित 15 दिवस के भीतर अवार्ड पारित न होकर दिनांक 22/3/2001 को पारित हो सका. जहां तक न्यायालय के द्वारा निर्धारित समय विधि का प्रश्न है, नए अधिनियम की धारा नाउ द कोर्ट सेज लॉर्ड, नए अधिनियम की धारा 34 में मध्यस्थ के द्वारा अवार्ड पारित करने के लिए कोई निश्चित अवधि निर्धारित नहीं की गई है. पुराने एक्ट में भी नहीं था कोई. द टाइम वाज फिक्स्ड बाय द कोर्ट. आर्बिट्रेशन एग्रीमेंट में कोई पार्टनरशिप डीड थी कि कोई डिस्प्यूट होगा तो इट वुड बी डिसाइडेड बाय एन आर्बिटर. दैट इज ऑल, नथिंग बियॉन्ड दैट. इसके अतिरिक्त यदि आर्बिट्रेशन अधिनियम 1940 के प्रकाश में इसे देखा जाए तो भी यहाँ पक्षकारों के द्वारा समय अवधि की मांग की गई. उभय पक्ष की सहमति से मध्यस्थ के द्वारा समय में वृद्धि, उभय पक्ष की सहमति से. दिस इज व्हाट ही सेज. देयर इज नो सच सहमति में लॉर्ड ऑन रिकॉर्ड. इफ अ लॉर्डशिप वुड प्रज्यूल द एंटायर आर्बिट्रेशन रिकॉर्ड, देयर इज नो सच सहमति. बल्कि तो हमने तो तुरंत जो है If your lordship would see the dates and events, I immediately filed an application, my lord, for removal of arbitration. 31 को लेटर भेजा, 7/4 को हमने दोबारा एप्लीकेशन फाइल कर दी, 5/11 को हमारी एप्लीकेशन डिसमिस हुई, 15 दिन के अंदर कंक्लूड कर। तो हमने तो कभी कोई सहमति दी नहीं। अगर हमने एक दिन अगर टाइम मांगा तो देना नहीं था उनको, क्योंकि he was required to adhere the strict time limit. Even the district judge could not have extended the time which was fixed by the High Court. He ought to have directed the parties to approach the High Court for extension of the time. He could not have interfered with the order of the High Court, my lord.
Yes.
So, my lord, it says, with the consent party, with the consent, उभय पक्ष की सहमति से मध्यस्थ के द्वारा समय वृद्धि की गई, तब न्यायालय के द्वारा निर्धारित अवधि के पश्चात भी अवार्ड पारित करने का पर कोई अनियमितता होती तो यह मान नहीं किया जा सकता। मतलब दिस इज व्हाट द कोर्ट सेज। So, my lord, if I succeed on this ground, my lord, I need not go into the other issues, my lord.
You are relying on 2020.
Yes, my lord.
2010 volume 2 SCC 385 paragraphs.
Yes, sir. Paragraphs, my lord. 2010 to SCC 385, my lord. The relevant paragraphs, my lord, are paragraph 3,
yes,
4, because the facts are to be ascertained,
yes,
my lord. 7,
yes,
9, 10,
yes,
12, my lord. 9, 10, 12.
yes.
For some time to argue the matter because arguing counsel is unwell. Next time may be granted.
102.
Yes, my lord.
Two 2004 मैटर।
Yes, my lord.
क्या है मैटर, क्या है? फाइल है? This is what, 482?
No, my lord. Service
Petition.
Yes, my lord.
Promotion matter.
Yes, my lord.
तो अब रिटायर भी हो गए होंगे।
Yes, my lord, but
Notional.
benefits.
He is more than 70 years.
Yes, my lord, it has to be argued finally.
So what you want?
My lord, I want some time, my lord, because
No, I will not grant any time. I will dismiss the matter.
my lord, he is unwell. Doctors have advised him to take
आप
rest.
आपने कुछ फाइल किया है क्या?
No, my lord, they have not filed the adjustment application. The adjustment was.
What happened to him?
My lord, pacemaker has been implanted in. That's why.
One more opportunity is granted to counsel appearing for petitioner for arguing the case after 4 weeks. It is made clear that if none appears, if matter is not argued on said date, then case will be dismissed for want of prosecution. Yes.
Matter can be disposed of with the direction. Actually, what happened? Petitioner got senior time pay scale on 26/10/96.
Yes.
Later on, his junior was granted same pay scale from 1 to 94. He filed a representation. The representation was decided without assigning any reason. Annexure P7 is the order of the impugned order.
Yes.
So they can be directed to decide the representation on merits.
Yes, आपने reply नहीं file किया?
Reply file.
Sent the letter also on last day, Your Lordship.
Petitioner has filed this petition under Article 226 of the Constitution of India, making following prayer. It is submitted that petition is pending for consideration before this court. Matter is admitted for hearing and reply is yet to be filed by respondents in the case. As matter is very old, therefore same may be disposed of, directing respondent authorities to consider his representation contained in Annexure P8 and pass reasonable and speaking order on it. Government advocate submitted that representation filed by petitioner will be considered in accordance with law. Considering aforesaid facts and circumstances of the case, writ petition filed by petitioner is disposed of, directing who will decide?
Respondent number 1.
Directing respondent number 1 to consider and decide representation of petitioner contained in Annexure P8 within period of 60 days from receipt of certified copy. Full stop. No opinion is expressed on merits. Petitioner is directed to file copy of representation along with certified copy before respondent number 1. Disposed of. First.
Number 104.
In this matter, my senior is adjusted and we have filed the adjustment.
Counsel for petitioner is adjusted. List after 4 weeks. It is made clear that if case is not argued on next date of hearing, then matter may be dismissed for want of prosecution.
Number 106.
Yes.
Yes, Lordship. Your Lordship, we are challenging the order dated 10/1/2003 that is passed by Labour Court and appellate order dated 7/1/2004.
So this
passed by
petition is not by you. जो प्रमोद कुमार वाला दिया है आपने
6.
Yes.
Dated 10/1/2003 passed by Labour Court and appellate order dated 7/1/2004 passed by Industrial Court, that is P6, Your Lordship.
Yes. Who is appearing for other side?
Kumar Khare.
Let him appear.
Yes, yes.
The counsel for respondent is granted one more opportunity to argue the case after 4 weeks week commencing.
Number 107.
Kindly connect this matter through VC, my lord.
Lord, I believe the respondent has expired. That's what my instructions are, because he was very frequently visiting to our company the last couple of months, maybe year, Lord, that he has not visited us.
Yes.
Lord, a week's time may be granted to verify the same, my lord. We are not in contact with
Then to file an affidavit that
So If you are not able to contact,
The week time may be
I'm
granted.
sorry, my lord.
Get no information regarding the death of the respondent.
counsel appearing for respondent number 2 prays for short time to inform the names of legal representatives of respondent number 2. List after
2 weeks time may be granted.
2 weeks. Week commencing.
Very good.
Number 108.
Hello, by way of this petition, we've challenged the order of the learned labor. Hello, there was a matter whereby
Yes, who is appearing for respondent?
Mr. Ashish Tiwari. He hasn't been appearing since the last few dates. I had sought time on the last date of hearing.
Yes, what is the matter?
Well, the matter is that reference was made to the Sagar Labour Court, whereby an order was passed dated 24/1/94, that is P1, my lords.
Yes.
Whereby, my lords, the corporation, municipal corporation, was directed that the Safai Karmacharis, there were a set of 52 employees, my lords, they may be granted regular pay scale and the arrears of salary. And there was also a directionary given to the corporation.
Let respondent appear, last opportunity kar dete.
Right.
After 4 weeks, last opportunity to respondents to appear and argue the case. It is made clear that if no one appears for respondent, then matter will be heard ex parte.
Grateful, sir.
Last date of hearing directed to seek instructions in this matter.
Regarding what?
Whether this exists.
Yes.
As per the oral instruction by district education, the school which was run by grant, your lordship. Now grant has been stopped from government and school does not exist, your lordship. That is the contention, but still I'll pray a short time, file an additional reply.
ये पहले बार तो आपने रिटर्न फाइल किया हुआ है. इनको गुरुजी की पोस्ट चाहिए. Petitioner, any objection?
मतलब केवल इसको डिस्पोज आपके लिए मेरा रिक्वेस्ट था, मतलब केवल ये बेनिफिट देते हैं गुरुजी वालों को, इतने नंबर का बेनिफिट देंगे यदि अदर कहीं हम भरते हैं तो, और उसमें एज रिलैक्सेशन देते हैं जो इनकी नई पॉलिसी आई है.
कौन सी पॉलिसी है?
वो पॉलिसी मेरे पास नहीं है मैडम. कल ने मतलब जो डेट है चाहते हैं
वो पॉलिसी देख लें आप. You also find out the policy, and if there is some policy, give him also the benefits. Government, how much time? Government advocate appearing for state pays for 2 weeks further time to seek instruction in the matter and argue the case after 2 weeks commencing. No further adjournment shall be granted to respondents.
Number 110.
For want of work.
Number 111.
Same.
Number 112.
Same.
For 113.
Same.
For 114.
इसमें अभी मैसेज आया तो अभी ये सर इसका मैसेज आया लिस्ट होने का. No, ये सबमिशन दिस मतलब इट में भी टेकन डे आफ्टर टुमारो.
क्या मैसेज आया है?
केस लिस्ट होने का मैसेज आया. कल तक की लिस्ट में नहीं था, अभी मैसेज आया लौट से.
क्या कुछ है इसमें? इसको सरवाइव कर रहा है?
फाइल नहीं है, फाइल नहीं आ पाई है. डे आफ्टर टुमारो के लिए हम
Counsel appearing for petitioner prays for last opportunity to argue the case. Prayer is allowed. 4 weeks time is granted to counsel appearing for petitioner for arguing the case. No further adjournment shall be granted.
For 150.
Same.
Bill number 115. Bill number 117.
For 116, Your Lordship.
Yes.
Your Lordship, this is a present matter wherein under Your Lordship, Annexure P1 is the order which was passed by the State Administrative Tribunal for the payment of retiral dues, Your Lordship.
Yes.
Payment was to the tune of rupees around 76,000, Your Lordship.
Yes.
76,994 rupees along with interest till the amount has been paid, Your Lordship.
Yes.
Been submitted that that amount has not been paid till date, Your Lordship. The retiral benefits have been held by a bounty.
Yes.
And no reply has been filed by the state after
Yes,
the
state.
passage of 40 years, Your Lordship.
इसमें क्या आप reply file करेंगे? Comply with the order. Yes.
Already notified.
Yes, yes. Pay it with interest. Petitioner has filed this petition under Article 226 of the Constitution of India, making a prayer that respondents be directed to comply with order dated 17/9/90. It is submitted that Madhya Pradesh State Administrative Tribunal, is what, Jabalpur has passed an order directing respondent authorities to pay an amount of 76,994.83
along with interest
within 1 month to petitioner along with interest of 18%. Interest has not been properly calculated by applicants. क्या लिखा है? तो काट देने से पहले क्या लिखा है? And to pay an amount, principal amount of rupees 76,994.83, full stop. That amount will carry an interest from 11,789 at the rate of 18% per annum. Full stop. Order has not been complied with by respondents. Neither any reply has been filed to writ petition. Next, in these circumstances, writ petition is disposed of. Directing respondent number. Director. Respondent number 2. To comply with order dated 17/9/90 within period of 30 days from today. If said order has not been set aside by any superior court of law, by appellate authorities, with aforesaid direction, petition is disposed of.
For 118.
117. 117 में क्या होगा? 17 भी हुआ क्या? Yes, 117 फाइल अभी दी. Yes, क्या कहना आप?
एडजस्टमेंट नोट में क्या शो करवा?
Arguing counsel is adjusted. Yes. Case is adjourned. After 4 weeks commencing.
Number 8. 118.
None appears dismissed for want of prosecution.
Case number 190.
I want to withdraw this. Raise for withdrawal allowed, dismissed.
120.
Commission for grant of promotion from the date as given to his junior, my lord.
Yes.
This case, my lord, the petitioner is working with the state legal authority. State legal authority. Yes, state legal authority is the
Reply आ गया.
reply आ गया, my lord.
Nobody is appearing.
हर्षित पटेल आते थे, बीच बीच में कभी आए हैं. केस तो बहुत दिन बाद लगा है.
One more opportunity is granted to respondent to argue the case. It is made clear that if none appears, ये इनको बोल देना स्टेट लीगल सर्विस अथॉरिटीज वाले रजिस्ट्रार कोई रिप्रेजेंट नहीं कर रहा. Granted one more opportunity to argue the case just after 1 week. It is made clear that if none appears, then matter will be heard on its merit. None appears for petitioner. Dismissed for want of prosecution.
Number 122.
Same order.
Number 123.
जितने dismissal हुए, application for restoration will only be considered on deposit of cost of ₹25. Legal aid. Yes.
My lord, here in this case, during the pendency of the petition, my lord, petitioner has superannuated, my lord, in 2019, my lord. Basically, my lord, it's a second round of litigation before this court, my lord.
Who is appearing?
State is the main contesting party. Here in this case, my lord, the petitioner is claiming the regularization of the regular pay scale, my lord.
Yes.
It's the second round, my lord. Earlier, original application was filed before the erstwhile state administrative tribunal, my lord.
Yes.
That was disposed of by this honorable court, my lord, by annexure P2, my lord. Herein,
Yes.
my lord, it was directed to the respondent to investigate, my lord, whether the averment of the petitioner is correct or not, my lord, that her juniors have been given regular pay scale or regularization, my lord.
Yes. Yes.
गलत फाइल दी है आप.
Yes.
123.
Yes.
Annexure P1 is the order, my lord. After the order of the Honorable High Court, my lord, order of annexure P1 has been passed, my lord. In paragraph number 3, my lord.
High Court only directed inquiry.
Yes, my lord. My lord.
Yes.
They did not conduct any inquiry, my lord.
Yes.
In terms of the order of the Honorable High Court, my lord. Paragraph number 3, my lord, may be seen of this order, my lord. Shri Rajendra Singh Rawat एवं श्री page 10, my lord.
Yes.
श्री राजेंद्र सिंह रावत एवं गौतम सेन गुप्ता एवं अन्य 16 कर्मचारियों के संबंध में याचिकाकर्ता द्वारा दिए गए उदाहरणों अनुसार अभिलेखों से इसकी पुष्टि नहीं होती, ना ही यह जांच का विषय है. Now, my lord, kindly see annexure P19, my lord.
Yes.
These were the juniors of the petitioner, my lord. Annexure P19 is I have filed, my lord, along with my rejoinder, my lord.
Yes.
Page number 5 of my rejoinder, my lord. Pagination starts from annexure annexures, my lord. Page number 5, my lord. The name of Rajendra Rawat is reflecting.
Annexure you are
rejoinder, my lord. Rejoinder से देखेंगे sir.
rejoinder.
जी rejoinder.
Yes.
My lord, annexure, first, my lord, I would refer the annexure P18, my lord. Suresh Kumar Prajapati. This is the order of Suresh Kumar Prajapati, my lord.
Yes.
His appointment of 31/1/1986, my lord. He is junior to the petitioner. Petitioner was appointed in the year 1985, my lord. Annexure P4 I have already filed before your lordship.
Yes.
Now, my lord, kindly turn to page. Next page, my lord.
इनका कब का है सुरेश प्रजापति?
इनका सर 86 का है. 31/1/1986, my lord. Annexure P18, my lord.
Yes.
आदेश है. Now, my lord, kindly turn to next page, my lord.
Yes.
After 6, my lord. Suresh Kumar Prajapati. 28/12/2000. 28/12/1987, my lord. Second last column, my lord.
Yes.
This is the date of. This is the date, my lord, on which regular pay scale was granted to Suresh Kumar Prajapati, my lord.
Yes.
टॉप पे आप देखेंगे सर वेतनमान 950 1880 सबसे ऊपर my lord.
Yes.
No, my lord. Kindly turn to page 5, my lord. Rajendra Rawat, my lord.
Yes.
His name is appearing at serial number 4, my lord.
Yes.
He was also junior to the petitioner, my lord, but benefit of regular pay scale was granted to him. But petitioner has been denied, my lord. And my lord, I have filed the vacancy position in 2009, my lord, by way of an additional application for taking a document on record, my lord.
Yes.
I indicated the vacancy, my lord. That is annexure P2, my lord. Your lordship may find this document with an application for taking additional document on record, my lord. IA number, my lord, 2192 of 2009, my lord.
2009?
Yes, sir. Yes, sir.
Yes.
My lord, 2192 of 2009. I have filed one document that is annexure B22, my lord. It is dated 29/11/2008, my lord.
Yes.
Kindly see serial number 25, my lord.
Yes.
Assistant grade 3, my lord. Rikt Pad team.
Serial number?
25, your lordship.
Yes.
Sahayak grade 3.
Yes.
Rikt Pad team.
Yes.
This was the position in 2009, and petitioner is continuously claiming regularization since 1991 when her junior were promoted, my lord. So my submission before lordship, lord, now petitioner has been superannuated in 2019, my lord. The only benefit which remains, my lord, that is in respect of the monetary benefit, my lord.
Yes.
But maybe.
Yes, state.
The order of this for 30 days. Contact with the appointment. I was appointed.
Yes. I'll consider your reply. Hard reserve for order.
Number 124.
My lord, interim maintenance.
I'm praying for a week's time. Shri Abhijit Awasthi is adjusted.
ये क्या है? What is this?
इंटरिम मेंटेनेंस के खिलाफ मतलब इनहेंसमेंट के लिए आए थे my lord. 15,000 रुपए
23 का है?
120, हाँ 124 नंबर.
ये ऑर्डर की लिस्ट में कैसे आ गया?
वही my lord समझने आया कि डायरेक्शन मैटर में कैसे लगे. नीचे क्योंकि भी
first time list.
नोटिस हो गए.
नोटिस हो गए.
आप किसके लिए अपीयर हो रहे हैं?
Respondent.
हस्बैंड.
File your reply. Counsel appearing for respondent prays for short time for filing reply and to argue the case. List after 4 weeks. You may argue also directly.
Not any fixed date.
Record will not required. Interim है ना?
Interim, my lord. Kindly any fixed date, my lord, की final बहस हो जाए उसमें.
फाइनल अपील है 323 में 1 महीने की, 324 में 6 मंथ की है. मैं हमारी अंडरग्राउंड के प्लेयर
Probation पे allowed. Disposed on. Bond भर दीजिएगा. Yes.
Which was fixed for today. I don't think Lordship would be having time for that.
Yes.
Item number 100, so that's 482 for pashment.
When you want it.
Whenever it is convenient, this week itself we can argue it out.
Who is appearing? State?
It is the state, the other party is one ex-party. The case of consensual relationship over a span of time.
100?
Ji.
Two weeks कर दें. तो fixed date दिया था. I have given a fixed date in this matter.
Today was the fixed date today, sir, given. Of today it was given.
कब का है छुट्टी कब से?
You start from 22nd, the holidays.
Last को चालू है. अप्रैल में
1 तारीख को चालू हो रहा है.
1 को चालू हो रहा है. 3 को लगा, ट्यूसडे को लगा.
Wednesday होगा सर. Wednesday. जी. Grateful sir. IR में kindly continue.
IR to continue.
application the new address the respondent document application.
It is at initial stage. अभी तो नोटिस नहीं हुआ है ना.
नोटिस हो.
ये आइए मैडम इसमें अलाउ कर दीजिएगा. आइए नंबर 3491 of 24 is allowed. Necessary amendment be incorporated within period of 1 week. If necessary steps were taken for incorporating amendment, then notices be issued on payment of PF within 7 days. कर दिया है. Yes.
My lord, at item number 84, my lords have given a fixed date of today, my lord. I have made a request also, my lord, and my lords were kind enough to give the fixed date of today, my lord. Not the matters fixed for evidence, my lord. Not any fixed date may be given, my lord.
ये next week का.
84. Next week, my lord.
Yes.
Could it be in the week of April? छुट्टियां हैं पूरी फिर. Any fixed date, my lord.
Second next week में करना अप्रैल में. First
fixed date,
week में मत करना उसके बाद वाला.
Serial number 56 my lord.
Yes.
Application application.
Item number
66 my lord.
66
my lord.
तो dismiss हो गया है.
59 तक.
Yes. क्या चाहिए इसमें?
इसमें सर 117 की जगह पे 127 हो गया मतलब 177 हो गया ना करेक्ट.
Applicant has filed an application for modification of order dated 12/7/23 passed in MCRC number 29886 of 23. Counsel appearing for applicant submitted that due to typographical error, crime number is mentioned as 177 of 22. Correct crime number is 117 of 22. Full stop. It is submitted that same may be corrected in order dated 12/7/23. Actually, application is allowed. Order dated so and so be read as so and so in order dated so. Disposed of.